have forgotten to move the decibel 2 places. I would have, I did make some decisions about those things. And so I'm going to let you respond to that and complete a record on it. Mr. Aiello, I will certainly allow you some time if you need it to prepare rebuttal evidence on those issues.
Your Honor, may I just be heard on one more thing and then
Of course
I'll
you can.
drop it?
You don't have to drop it. You're doing
Okay.
fine. Do your work.
Okay. Your Honor, with regard to the evidence that Your Honor allowed at the ORCP 79 hearings, I would just like to state for the record that in those hearings, the court was balancing the harms of stopping the measure against the harms to Oregonians of allowing the measure to go into effect. And so when the court made those determinations regarding percentages and numbers, plaintiffs would assert that that was the court doing the balance of harms analysis required by ORCP 79 and not engaging in a facial analysis of ballot measure 114 for constitutionality. And that's what plaintiffs understood, that statistical evidence to the relevance of that statistical evidence at the time of the ORCP 79 hearing. So plaintiffs would ask that that evidence remain excluded in accordance with the court's prior rulings on motions in limine.
May I be heard, Your Honor?
Yes.
With respect to evidence presented on the preliminary injunction hearing, in our view, that is not part of the trial record in any case. Under Rule 79C2, that would require a stipulation of the parties, and the parties have not so stipulated.
Mostly work. Yeah.
So then I'm not bound by any of those statistical determinations I made before, is what you're telling me. And now I have to decide based upon this record whether or not I'm going to allow in this additional evidence around on a facial challenge to firearm statistics and homicides and whether that's relevant to the court's determination.
Yes, Your Honor.
A rare point of agreement between plaintiffs and defendants, Your Honor.
All right. Well, hell, they might be over for the day. What's up, Tactical Fud, my brother? What's happening? All right. Well, hell, they might be over for the day. Oh, shit. What's up, Tactical? Shut down the echoes real quick. Keep in mind, I didn't think they'd be shutting down yet. But they might be. I wish there was a way to go back and watch this, but I don't think there is. I don't know. They might just be on a break, so we'll hang out. Yeah, same here, Fudd. I just walked in the door, just got stuff set up. I was streaming this today while I was at work, just letting stuff play, just to be able to listen to it. I wonder if that's our brother DJ hanging out right there. So we'll see what these cats do. They may not be shut down. If they aren't, we'll pull them back up. Let me stop that screen share. Yeah, if they aren't shut down, we'll bring it back up. I still got it playing. So we'll see what they do. Tomorrow I'm gonna be fucking busy, but I am going to try to stream some more of this because I can't find any link to just be able to go in and just watch the video or download the video. And I know G23 was looking for it too because, of course, he's up there and he wants to cover it too. So we'll see. Yeah, Fudd, that's cool, man. It was just I didn't have time to watch. GT3 just told me or gave me the link and stuff because you got to watch this. They got it set up through fucking WebEx instead of just running a normal stream. What's up, Vanessa Kitty? What's up? So I can't find a place to just go in and pull videos. So that's why I went ahead and streamed it today just while I was at work. PLA, what's up, my brother? What's happening with you? So if they don't get going again, I've still got some other stuff we can look at. Let's put it that way. And we can still look at politicians doing dumb shit and trampling on your rights. Funny how that works, ain't it? And over here dropping shit. Oh, let's see. I tell you what I might do. We might do this. Let's see. My computer will act right. Which one is it? I got so much stuff freaking. Not that. That was something else. That was Mock Garland. Let me do something. Let me try to figure out what. So I thought we'd listen to some of this, but we might listen to it again anyway, just while we're killing time. Let's trip through this real fast. Let me make sure which one this is.
I want to back up and ask you what ago that it's the states maybe
they are the perfect instrument for loan
or is it
work, is that the state is only
individual right, but what are the arms field?
But we spent quite a bit of time in the first step. Let's move to the second step. We're supposed to ask the how and the why.
Yes, satisfy that standard. To the historical tradition. To the historical tradition. each of which.
So this was the Seventh Circuit. This was the Illinois mag ban and their assault weapons ban shit that they're going through right now. Some of this with the Floyd card was argued just the other day. But hell, we'll listen to this while we wait to see whether Oregon comes back up. Just for a reminder.
Provides an independent basis for this court to affirm the Bevis and Herrera court's denial of preliminary injunctive relief and reverse the Barnett court's grant of a preliminary injunction. We know from Bruin that courts must begin by assessing whether the regulated instrument is protected by the plain text of the Second Amendment. We also know from both Bruin and Heller that not all instruments fall within that category. The instruments must be arms, they must be bearable, and they must be in common use for self-defense. The instruments at issue here do not satisfy.
Now, see, that's one of her lies right there. They don't have to be in common use for self-defense. They just have to be commonly owned. See, this is the sneaky shit they're going to try to pull. They're going to try to say, well, they got to be in common use for self-defense. And their version of self-defense is actually pulled the trigger and shot the bad guy.
Satisfy that standard for at least two reasons. First, large capacity magazines are not arms. They are accessories that are not necessary to the operation of any firearm.
And I take it when you say that, you're
yeah, Sam,
understand
100%.
some sort
Man.
of
That's
ammunition
why the
feed
share the
device.
pain streams are the way they are.
10-round
It's
device,
funny the way
for
they
example.
argue it, but it pisses you off because
Yes, of course, Your Honor. At issue here are only the large capacity magazines that
dicking
are
with your
restricted
rights.
by the Act. The Act does not restrict anybody's ability to use a magazine to operate their firearm. And because the record here plainly shows, and it's unrebutted by the plaintiffs, that there is no need for a magazine in excess of 10 rounds for rifles or 15 rounds for handguns, that they do not constitute an arm under the Second Amendment. Even, however, if that were not the case, large capacity magazines and assault weapons fall outside of the plain text because they are
DJ,
not in
what's up,
common use
brother?
for self-defense.
There's much discussion, Ms. Hunger, about a burden. I think the state, the county, the Naperville all place a burden on the petitioners for purposes of establishing this first step. Where is that found? What's the authority for that?
In Bruin, there are several if-then statements that says if the weapon is within the plain text of the Second Amendment, then the government bears the burden of demonstrating that is consistent with historical tradition. If the government bore the burden at both steps of the analysis, then the Supreme Court would not have used that language.
Well, Bruin is clear that the government's got a role here on the second step. It says so.
That's
Bruin never says the burden shifts from petitioners to respondents. We're left wanting for the source of authority as to why a burden on the first step would be on the petitioners, aren't we?
Well, I suppose
I'm
the
gonna
burden does
post,
have to be on
locked
somebody,
and loaded
and we
with
know that the
Tino's
government does bear the burden on
channel
the
in the
second
chat.
step.
They
And
should
as
be
I
going
said,
live
there
in
is
just a little
that
bit.
kind of if-then language.
So if you guys follow
regardless
Locked and
here,
Loaded, they're gonna be
whoever's
going
burden it
live.
is, our position is
I'm probably gonna
even
hang
before
out and
the
listen to a
government's
bunch of dumb
burden,
shit for a
that these are
little while.
not in common use for self-defense. That's because assault weapons make up only 5% of the arms in circulation, and they're owned
This
by
is
only
Illinois,
2% of
Sam.
Americans and 8% of gun owners.
Before we
And
get
these
too far
arguments
down
were
that
done-
path,
I think in June, I think's when these came through. And this is actually one of, I think, 3 different sets of arguments. Dude, FUD. Get with me, man. If you want to sign, get with me. We'll get you one. Oh, let me show these off while I'm thinking about it. I'm going to make myself big and bigger for a second. So my man, Chris from the 740, sent me some swag the other day. So hell yeah. Got some 740 swag kicking. We'll go there. We'll go here.
Which we certainly should come back to because there's a great debate going on
RTAC,
about
what's up,
what
brother?
we're talking about when we talk about common use. Are we talking about numbers? Are we talking about purpose? Are we
If any of you guys are up in Illinois,
and
this
to
is
what
your
extent
show.
do we anchor this in a particular point in time? But I want to back up and ask you what the state's definition of a bearable arm is. Does that mean something you can carry, or does that mean something that were ordinarily in 1791 in someone's household? Or what's a bearable arm?
Our view is that it likely would
shit.
mean something that someone could carry, and that is why it is our view that it is not an appropriate standard.
Yeah, Chris got
for
some nice ass
plain
patches,
text
bro.
stuff, and why it makes more sense to look at whether or not something is in common use for self-defense, or else, you know, you could literally have shoulder-fired rocket launchers would count as bearable arms, and then
Yes,
you have to go into the second step of the analysis and do this huge historical inquiry when everyone knows those are military-grade weapons that are not protected by the Second Amendment. And so,
Well, and I take it your opponents concede that even M16s are not the kinds of arms that the Second Amendment protects for personal use for self-defense.
that's
No,
correct, and
that's
that's
not
a
what
really
they said.
important point, Your Honor, because
Warsaw!
assault weapons are virtually identical weapons to M16s, but for one thing, which is that M16s can use automatic fire instead of semi-automatic fire. And sure, that is a distinction, but it is not one that's constitutionally determinative. If you look at
We'll see. This is where we get into this idiot argument where we let the government start trying to pick which guns you can have, which guns are bearable, what you can do. No, that's never the way to. I can prove it easily in historical law that at the time of the founding, people, average citizens, owned every implement of war that the government owned. That's why they in the Second Amendment, when they were going through and they're debating what should be in the Second Amendment, they never said, oh, well, your average citizens can only own guns if they're not government guns, if they're not military grade. That's never fucking mentioned in the Second Amendment because the Second Amendment was supposed to be a balance on federal power. So they flat out in the amendment says it's the right of the people to keep and bear arms, and it shall not be fucking infringed. Now, they didn't say fucking. Maybe they should have. Maybe it would have thrown a little bit more emphasis on there. But the term shall not is a legal term. It's the strongest legal language you can use in a legal document. It doesn't say may, doesn't say should. It says shall not. Douchebaggery.
you know, what Heller.
No, Warsaw. This was the older arguments that happened back in June when this originally went through. So as far as I know, the court's still juggling on this one, or hell, maybe I think the 7th upheld all this bullshit. So it's supposed to be moving up from there.
Said about M16s, the reason why the state may ban them is because they're weapons of war. It's not because they use automatic fire. And
see, here's the deal, Hobag. Almost any vet that I know that has carried an M16, carried an M4 will tell you it was rare for them to use it in full auto. It was almost always in semi-auto because it's more controllable, it's more accurate that way. The only time it was in full auto was oh shit, we're getting attacked and we need to throw more lead in the air than what they're throwing in the air to get their fucking heads down so that we can move. And typically, that's what machine guns are for. Your 240s, your 249s, your fucking Maul Deuce. Well, the thing is, dude, if you can afford an RPG, you ought to be able to fucking get one. Here's a clue. Just don't go wrongfully deprive someone else of life, liberty, or property with your fucking rocket launcher, and we're all good. What's up, JLM? What's happening, brother?
And so, yes, plaintiffs have identified that distinction, but they have not explained why it's important.
Yeah, DJ, you hit that perfectly. Military grade. Military grade, to put it quite simply, is probably the lowest grade on the fucking market. It's a marketing term that they use all the time. Oh, this is military grade. Military grade shit sucks. It just does. That's why a lot of your special operations troops and things like that, they're not getting military grade shit. They're getting shit basically from the private sector and then using it in a military role. That's why, the HK-416s and all that. Hold on, we got something going. I'm hearing noises. Fuck, I'm going to have to do this entire screen, I think. So I'll be back in this little window next to the fucking screen over here. Let me know. Make sure you guys can hear this.
Your Honor, I apologize. We're grabbing the lawyer in question. Apparently he stepped out for just a moment.
I should have looked around before I started.
No problem. We'll get him right away.
Sorry.
Oh, a fucking lawyer on a smoke break? I can believe that. Good deal. Tomorrow ought to be an interesting day for this case because they're winding down tomorrow. I wish I had the first 3 days when they went through and questioned some of the witnesses for the appellates and shit.
So Christian outlines that the court should look at conduct restrictions on gun rights.
I heard that, DJ.
Within the framework of whether there's an unreasonable or unjustifiable risk to the public if the
chain. Now that makes me want to hear
not allowed
chain
to be
of
in
force.
effect. In other words, the magnitude of risk of harm to the public that the law seeks to address. Now, I can look to ballot measure 114's language for the legislative intention of and what they say within the
What's
preamble.
up, brother P38? P38, I still got to get up to your neck of the woods and have another beer with you.
And determine that they say that that's the magnitude of the risk of harm to the public that the law seeks to address. Is that what you're asking me to do?
Yes, Your Honor. Yes, Your Honor.
And that then the next question is whether the law reasonably relates to that purpose and whether the law unduly infringes on the right to bear arms for self-defense. And that's the Christian test, right? At 38, page 38. Why would I allow any additional evidence beyond the voter's pamphlet, the preamble, and the voter's pamphlet for the legislative history? I think you said that that would be sufficient.
Your Honor, our understanding of the Christian test is that the courts would not defer to every legislative finding necessarily. And so, and we certainly understand the plaintiff's position to be that we have to prove it. Now, maybe that just changed in that colloquy, but in the pretrial brief, the plaintiff's position was we are required to show, in fact, a benefit to public safety, and this evidence is relevant to that. We have a different view of the test. We have to show that the legislative judgment was reasonable. So we are seeking to present reasons that the legislation was, in fact, justified at the time, not a prediction or a speculation about what the future may hold, but the reasons that the voters determined that it was. Now, if the court disagrees that we have that burden, hypothetically, if it disagrees that we have that burden and instead thinks that the legislative
the voters voted on this shit because they're morons.
On the judiciary, then I would agree hypothetically that this evidence would not be relevant because all that would matter would be the legislative findings, and the legislative findings would be sufficient to conclusively establish that there is a public safety benefit of Measure 114. We just think that we have a slightly higher burden to that, which is to show that it is a reasonable
Hell yeah,
judgment,
P38.
that at some level, under a deferential standard of review, effectively the legislation had a rational basis to believe that those things were in fact true.
I mean, I'm going to let you then bring in that particular evidence about the magnitude question, and the court will make determinations as to the magnitude of the problem. Which is what Christian says, and if you wish to take that burden on yourselves, I will give it to you.
Well, again, there is no balancing test anymore.
I need my notepad, which I took back and put in the chambers. So I'm fine. We can move forward with the testimony on homicide statistics, gun mass shooting statistics, the weapons used in those.
Does the court have a written copy of the slides? Did I hand that up or not? Yes, that would be it. So I was intending to present that to the court as a bench copy. Should you prefer that, we'll also put it on the screen. I believe Dr. Siegel is still on the line.
So I do want to note that if this causes you to want to call a different additional witness in rebuttal.
Yes, Sam, that would be a slick build.
Mr. Aiello.
Thank you, Your Honor.
I understood your position, and I understand it. I think the Christian test does require some determination on the magnitude of the public safety problem and whether the corresponding legislation is a reasonable response to the magnitude of that problem.
Your Honor, may I ask a question?
I'm fine with you asking questions.
Mr. Marshall laid out a list. I think I have the list accurately written down of the evidence, and I think it would be helpful for plaintiffs if we could just go through that list and have the court say whether or not the court's going to allow that evidence, or is the court's ruling that all of the evidence Mr. Marshall listed is going to come in?
Well, I'm not going to allow the permit to purchase comparisons to other states.
There is no entrance balancing anymore. Public safety.
And as for the completed background check or Charleston loophole evidence?
Oh my fucking God, why are we talking about this shit?
Again, that's more of an as-applied question, isn't it?
GT3, I'm sorry, man. You need to immigrate to Alabama.
Your Honor, I thought you ruled yesterday that the
build a wall,
permit to purchase
Pacific
and
North,
the completed background check or Charleston loophole that they rise and fall together. I mean, we obviously disagree with that. We argue otherwise in the pretrial brief,
Sure.
but the court has ruled on that question. And so
I'm just looking at the Charleston loophole thing where it says a permit holder and continues to repeat permit holder throughout that, as saying to myself, oh, that seems like it's part of the permit to purchase program. But I understand you disagree. So the answer is yes.
No, Sam, that don't make any sense
I'm
to
not
me
allowing
either.
that type of evidence in because it's part of the overall permit to purchase program, and I'm not going to hear additional evidence on that. That would be later an as-applied challenge if this law goes into effect.
Your Honor, and then the effect of other states' bans on so defined large capacity magazines, is that in?
I've been paying attention
I guess
to
it
them
depends
too. So.
on what I'm trying to determine is we have this sort of broad cultural question first, the culture question in the sense that they're gun
I wish
owners.
they put this shit on a normal.
There should be no restraints. There are some who
stream.
believe you should have complete restraint. There's middle ground issues.
So I could
All that's a
download the
cultural
video,
question,
back it
political
up.
question outside the scope of the court's inquiry. The question on large capacity magazine bans is, does the large capacity magazine ban in one state look like the one here?
So only if it's identical?
It would have to be, I've said identical, but obviously if it is narratively the same, close in to the same.
And the mag bans are unconstitutional, you
If
fuck.
it's not, then I won't. The
And
reason
then-
that's different in my view is because the permit to purchase is so,
And Your Honor, I'm sorry, I'm just asking these questions so I don't object incorrectly in the middle of defendant's presentation of evidence.
the answer to the large capacity magazines, if it's the same type of large capacity magazine ban, I'll hear evidence regarding the efficacy of that.
And then the other ones, I think I can cover in one would be
Look who
caliber
I got a
size,
message from.
numbers of homicides,
One
numbers of
from
mass
Warsaw.
shootings with so defined large capacity magazines, and numbers of fatalities. My question is, for those ones, are those in, out, or limited to Oregon?
Upcoming Brady events. Here's some of the ways you can take action.
When we're speaking about the magnitude, plaintiffs would expect
Yes,
that we
I
would
follow
limit it
Brady
to
and I get emails.
Oregon
from him.
only. You know, the number of homicides completed with a firearm in Texas has nothing to do with Oregon. So I just, Your Honor, I don't want to object on incorrectly or unnecessarily. So I'd just like to fully understand the court's ruling.
Dude, object on everything. For the
Well,
love of God.
I mean, really, this is an Oregon inquiry only. I mean, shouldn't, when the court talks about, when Christian talks about the magnitude of the problem, they're focused in on Oregon specific laws and the impact on Oregon specific issues. So why wouldn't I limit any additional testimony to issues in Oregon?
So
I
the
gotta
ultimate
get with
judgment,
Warren
Your Honor,
Power.
I think will be about whether the legislation has a public safety rationale in Oregon. But the evidence relevant to that question is not limited to Oregon alone.
Shit, that's what I was getting on there.
In Exhibit 102, page 215 through 20, that's part of the preamble of Measure 114. The voters of Oregon explicitly rely on the evidence developed from bans of large capacity magazines in other states. They've
Which
looked at that
haven't
evidence,
done
and that's
shit.
a reasonable judgment to say if it worked in California, if it worked in New York, that maybe we should try it too. I mean, that's kind of the laboratories of democracy
Tell me
idea.
how
That's
a
not an
magazine ban
irrational
in California is working.
for
you
a legislature
motherfucker.
to make as to what
gonna be
they
one of them
wish
nights.
to do. And and I don't think it is at all irrelevant that there are mass shootings elsewhere in the United States.
Yeah, 100%. Sam.
That have harmed people, and for people in Oregon
First of all,
to
that
make
magazine didn't
legislative
harm any
judgments about
goddamn
the
body.
harms they wish to protect against in Oregon based on their recognition of harm elsewhere. If you knew that there were, if there was the only study that had occurred about a particular disease occurred in New York, but you had no reason to think that Oregon's population was different, you would still say that the legislature may want to take public health measures against that disease.
That hadn't hurt anybody.
The legislature just is not bound by those kinds of evidentiary determinations in the kinds of reasons that they can give for their legislation. And this is overall, the question is whether the legislature,
Welcome to the shit.
the legislation is reasonable. That is, did the people make a reasonable judgment? Their reasons can
No.
include evidence from other states.
Because your people are fucking idiots.
It talks about the magnitude of the risk of the harm to the public. That trips me up in terms of your.
You want to know what's a risk to harm to the public?
The magnitude of
Those
harm to
motherfuckers
Oregon
sitting in that
is
courtroom
specific.
trying to take your rights.
I can understand that theoretically they're entitled to, the legislature could say, we see these things have worked elsewhere, we'd like to try it here. That is contained within the legislative history. That there have been mass
you're
shootings
100% right, Warsaw.
elsewhere is certainly something they can consider when they make legislation, including that the diseases exist. The question, I guess, is for a constitutional issue, which is not generally a variant of a disease, is the magnitude of harm in a
No,
particular
you don't have a
place.
constitutional right to not catch her.
And that is true, the risk of harm in a particular place, but that doesn't only limit, that determination need not be limited to evidence from that place. That is, the people of Oregon don't have to say, well, it only happened in Las Vegas, I don't need to worry about it. That's not the requirement of the Constitution in any sphere. They can look to the evidence of harm elsewhere. They can look to the success of policies
playing a
elsewhere
game
as
of we
their
win
public
no
safety
matter what.
rationale. In fact, they did. They're looking nationwide. They saw those pieces of evidence, and they relied on them. And they're not barred from doing so.
No, what they are barred from is this entrance
test. This evidence falling into two issues: one, defining the problem; two, the solution. Obviously, defendants could not cite to a so defined large capacity magazine ban from within Oregon, as Oregon has not done so. So looking at other states that are more of an apples to apples comparison makes sense to plaintiffs. What doesn't make sense is how a law in Oregon affecting Oregon gun owners
ADX, what's up, my
have
brother?
any effect
Yes, we ought to
on
have
shooting in Las Vegas.
And Your Honor, all the
brother.
arguments,
Yeah,
I think, go to the
man.
weight of this evidence and not the
shit
admissibility. The court, as fact finder, could determine that the history in Oregon is the most persuasive evidence of the risk of harm in Oregon. We think that there is another way to look at that, and also to include the harms that have occurred outside of Oregon. And that is what the voters have done. And I think that they're entitled to do it. And the fact finder in this case, and then the finder, ultimately the legal determination about whether it's reasonable, both of those can weigh that evidence after it's presented.
It's still not fucking constitutional in your goddamn state.
Your Honor, plaintiffs would also just note for the record that this is, of course, assuming that the court finds that this is a manner of use, manner of possession type law under Christian. Just for the record,
ADX.
That's plaintiff's position.
I mean, I really find I'm just going to say out loud that I find the first two prongs of Christian somewhat hard for a court to make those type of public policy determinations. I think that the legislative body made determinations. They believe that there's a magnitude of harm that needs to be addressed, and that the law is reasonably related to that purpose.
It
really
is not the government's
ultimate
fucking
job to
job.
be upon is whether the law unduly infringes on the right to bear arms for self-defense. That's really ultimately the question, which goes to the fundamental question of Christian versus use, possession questions, and whether the restraints contained within ballot measure 114 are so onerous as to violate Oregon's constitution. There are, under Article 1, Section 27, that analysis. There are other analysis that I'm considering, obviously. I've been playing about that, but I think there are significant search and seizure issues with regards to provisions in Section 11. I think there are significant problems with regards to the constitutional standard that this provision of law outlines for when an officer can deny a person access to a firearm by making it a reasonable grounds determination just on how an officer looks at another person and decides based on their state. I find that very problematic under Article 1, Section 9 and 11. So I'm thinking about those things as well. I've been trying to be plain about that from the beginning. The first two prongs of Christian seem to me to be determinative within the ballot measure itself. I mean, I guess the plaintiffs could present evidence to say there's not a magnitude of problem sufficient to warrant this type of legislation, but really that hasn't been the foundational evidence that's been put on by the plaintiff. The plaintiff has said, are these firearms that were used in self-defense? And by restraining this particular form of firearm, or at least under Article 1 or under Section 11, that would be an unduly frustrating infringement, an unduly infringing upon the right to bear arms. They haven't really talked about the magnitude of the the magnitude of the problem, the risk of harm to the public. But I think that the defendants wish to present that evidence for whatever purpose they have, and I'll hear it. I think it's relevant.
Again, there is no
Allow them to ask
balancing
questions
test
about it, and I guess I'll
in
make
the
a decision
Oregon
based upon
Constitution.
what's presented by the defendants about the magnitude of the issue, if that's what you're asking me to
HBS,
do.
what's up, my brother?
Thank
It's
you,
a
Your Honor.
very, it's an interesting line that gets me into a very different place than what I think a judge's role is. But if this is what I'm supposed to do, according to the case law, I'm going to listen to that evidence.
Your Honor, we'll think you'll be able to defer to the legislative judgment in the end. It won't be hard. It won't be a close call, but we appreciate the evidence.
Well, I do think the question is based
Let me
on
I'll post this in
is
chat.
there a sufficient basis to infringe upon a
I
Second
have to do it in
Amendment
2
right?
parts.
And is what's being proffered as the policy decision to deal with that magnitude.
So
of
Oregon
harm.
Constitution,
Outside the scope
There's
of that
the first
magnitude of harm
part.
to the degree that the court finds it an undue infringement in ballot measure 114. I don't know if I'm saying that artfully. I'll have plenty of time to write about
damn
it
it.
and rewrite it later. But that's sort of,
here's the
I
second
didn't
part.
anticipate this evidence. So
There
I'm
is
sort of thinking
nothing
out
in
loud
there
about
that
how I want to
gives
handle
the
the
government
evidence
the
before
power
I
to
turn
regulate
it over
arms
to
in
you.
Oregon.
And I think I'm now more convinced that I should let you do it. So go ahead and call your witness, and I'll give you time, Mr. Aiello, to respond.
Where in those 2
cross,
things
as well
I
as
just
to offer
posted does it
additional evidence if you
say
choose to.
that the government of Oregon
Thank you, Your Honor.
can decide what arms its citizen owns? Where?
Dr. Siegel, are you on the line?
Yes, I'm here.
All right, Doctor, do you have your camera on?
Yes, it is on.
Oh, there you are. Gotcha. Go ahead and raise your right hand for me, please.
Who's
Under the
talking?
penalties of perjury, do you solemnly swear or affirm the testimony you're about to give
Okay.
to be the
yeah.
truth, the whole truth, and nothing but the truth?
I do.
Thank you. State your name, please, for the record, and spell your last.
It's Michael Siegel, and the last name is Siegel.
Go ahead, your witness.
Dr. Siegel, where are you joining us from today?
I'm joining you from Natick, Massachusetts.
How are you employed?
I am a professor in the Department of Public Health and Community Medicine at the Tufts University
see
School of
something.
Medicine.
Oh, this
Uh,
fucking douchebag.
Have you been on the faculty of other universities?
Yes, prior to coming to Tufts, I was a professor at Boston University School of Public Health for 26 years.
What training did you undergo before you took on those faculty positions?
Well, I have a medical degree from Yale University School of Medicine, and I have a master's of public health from University of California, Berkeley. I also
University
did a
School of
medical
Medicine.
residency
This is
in the area of preventive medicine and public health, which was at UC Berkeley as well. And finally, I was trained as an
That don't look like him unless
epidemiologist
that's a way older
at the
picture.
CDC, the Centers for Disease Control and Prevention in Atlanta.
So are you a physician?
I am a physician, although I do not currently see patients. I'm currently a professor, and as a professor, my roles are essentially half-time teaching students and half-time doing research.
What are your areas of scholarly focus?
The 3 main areas that I've studied
God damn
are
it, I can't talk.
tobacco, alcohol, and firearm violence.
I didn't know there was tobacco violence.
Have you published any peer-reviewed work
This
in
guy's
the area
practically
of
a
firearm
fucking
safety?
ATF agent all by himself.
Firearm violence, I guess is the term you used.
Yes, I have. I've published approximately 18 peer-reviewed
Dr.
publications,
Michael Siegel
articles,
started studying firearms policy
dealing with firearm violence, mostly
2012.
relating to analyzing the effectiveness
He attempts to
of
dispel the
state
myths of gun
firearm
ownership.
laws.
What are some of the
in
journals that you've
every
published your
town.
firearms research in?
Oh, guess who he's fucking working with?
I published in a journal called Injury Epidemiology, a journal called Injury Prevention. I've published in the American Journal of Public Health, the American Journal of Preventive Medicine, and also in JAMA Network Open, which is a
So this is
part of the
every
Journal of
town
the American
witness.
Medical Association, among others.
Are those peer-reviewed journals?
They all of them are peer-reviewed
Yeah,
journals.
ADX,
Yes.
100%.
Are each of them a respected journal in the field of
Chambers, my
epidemiology?
brother. What's up?
Yes, absolutely.
And are those journals well regarded as
Excuse me,
places
so let me do that.
for research related to firearms?
Yes, absolutely. All of the mentioned journals are viewed as highly reputable journals.
Oh, Sam,
including,
tobacco could cause violence.
the work
You
that they
take away my
publish
cigarettes,
related
I'm
to
probably
fire
going to get
violence
violent.
and safety.
We're going to now show you what has been previously marked as Exhibit 142.
Now, I wasn't paying too much attention. Did that slide mention that he's working with every town? From an outsider's perspective, gun violence prevention.
Dr. Siegel,
policy
what is Exhibit 142?
seems like a
This
high
is a copy of
position.
my curriculum vitae or CV.
Does Exhibit 142 fairly reflect your professional experience?
Yes, it does.
The plaintiffs move for admission of Exhibit 142.
No objection, Your Honor.
142 is admitted.
And plaintiffs, sorry, I said plaintiffs. The
So,
defendants moved. Sorry.
They got all over. I watched one
the-
thing.
And the
today.
defendants move to recognize that Dr. Siegel qualifies as an expert in the field of epidemiology and firearm safety research, as an expert in those disciplines under Rule
They got all
702.
over a witness for the appellants in the case, the people suing
objection,
about
Your
the shit. They got all over him, saying he was an advocate for firearms, not an expert. So why are we not all over this fuck nuts for being a goddamn member of every town?
In terms of fire, what were you saying about firearm safety? I'm a little confused. I mean, certainly in epidemiology, he's an expert. What was the specific qualification you're asking for him in terms of firearms?
Well, the witness testified that he has a scholarly focus on firearms violence or firearms safety. And so I'm recognizing that in that sub-discipline of epidemiology, that he has a specialization in that area.
Can he cite the general rules of firearm safety?
All right.
Could he field strip a Glock?
Subject to foundation, I'd allow that under 702.
Hey, my love.
Dr. Siegel, in preparation for your testimony, did you study the relationship between the use of large capacity magazines and the number of casualties in mass shootings?
Yes, I did.
And as a general matter, how do you and other scholars define large capacity magazines?
Typically, large capacity magazines are magazines that have more than 10 rounds.
Which is a made-up number they just pulled out of
How
their
do
ass.
you go about studying the question of the relationship between the use of large capacity magazines and the number of casualties in mass shootings?
Well, as with all public health questions, I reviewed the literature, did a search of the literature to identify all of the research.
Marjorie
all the studies
Stoneman
that if you looked at the question
Douglas.
of
dude
how
used
do the number of
10-round
fatalities or casualties compare in a mass shooting that involves a large capacity magazine
How do you
compared to a
something?
shooting that does mass shooting that does not involve a large capacity magazine. I identified those studies and then examined each of them to determine what the results of those studies were.
If they're shooting A with a high capacity
Why
magazine,
didn't you just look at one
it's not
study,
like you can
decide which study was the best
redo
and
shooting
just
A
use that one?
with a
Well, in epidemiology, we try to avoid bias.
and then compare
And if you just pick one study, one could easily pick the study with which, one wants to agree. We don't do that. We look at all of the evidence. We look at the totality of the evidence.
You conflate every fucking thing together and then lie about the numbers, you prick.
Is there a name for that approach?
It's sometimes called the sometimes it's called the totality of evidence approach. Sometimes it's called the weight of evidence approach. Sometimes it's called a systematic review or a scoping review.
And either way,
is that an accepted practice among epidemiologists?
To use
yes,
that
absolutely.
to strip people of their rights.
In taking that approach to this question, how many studies did you find?
I found a total of 4 studies that examined the question of whether or not there are more fatalities or more casualties when a large capacity magazine is involved in a mass shooting.
Let's look at slide 2.
Yeah, I guarantee you this dude can't, Sam.
Dr. Siegel, are those the 4 studies you found?
Yes, exactly.
Okay.
And what did those studies find?
These studies found that there was between a 2.2 and 2.6 times.
Plaintiff's object is outside the scope of epidemiology.
Yes.
Being the study of
diseases
and disorders.
Objection. And I realize I'm holding up 2 fingers.
Do you want to have
the number 2 objection
the foundational basis in his area of practice?
I could make a slide like that.
Dr. Siegel, I'll withdraw the last question. Dr. Siegel, how do you define epidemiology?
How was that data compiled?
Epidemiology is the study of the causes of disease. And
let's study the cause of violence like this. Let's do that.
Trained to study the causes of any and all diseases.
HPS, what's
diseases
up,
and conditions. Fire and violence is certainly one of the major areas of epidemiology. And so the study of fire and violence is part of the field of epidemiology.
And we already know the causes.
You asked me before what journals
we already know there are sick people
I've published in, and I mentioned one of them was called injury epidemiology.
We already know the vast majority
so
of it
clearly,
drug related, money related.
There is a field of epidemiology focusing on injury. I'm part of that field. I'm a respected researcher in that field, and I publish in the journal of that field.
Your Honor, may I ask a question in aid of objection?
Your Honor, my examination is not completed on this topic.
It's a question. Okay, you have more on the.
I have more on this particular question. Yes.
You can wait till he's done with his questions on foundation. When you're done, let us know, and I'll turn it to him.
Dr. Siegel, what is the relationship between the term epidemiology and public health?
Epidemiology is essentially a methodology.
He studies the rates of people getting herpes.
To public health. It's central to making decisions in public health because it's through epidemiologic methods that we determine, number one, the magnitude of the disease. Damn,
HPS, you haven't one in long days, brother.
Number 2, what's causing the disease? And number 3, what can be done to prevent that disease? And that includes things like laws and policies.
Yeah, because outlawing drugs has worked out so well.
I yield to Mr. Aiello.
Prostitution being illegal. Well,
good afternoon, Dr. Siegel.
Fucking been great, hasn't it?
Is a firearm injury a disease? Or
Oh.
a firearm injury is not a disease, correct?
Well, disease, I'm using, yeah, I mean, disease, I said disease or a condition. And so, I mean, epidemiology is the study not just of diseases, but diseases and conditions. Clearly, injury is a part of epidemiology.
Injuries are, but the violence causing the injury is not a disease or disorder, correct?
No, but I wouldn't, well, some people
Thank you.
could. Some
Yes,
people could speak
just
of violence
stop
as
him
a
right there.
disease, but
That's not
would
what I fucking
I would
asked.
say that the disease is the injury and the fatalities. The violence is the cause of the disease.
No, the violence is not
And
the
then Dr.
cause.
Siegel, for clarity, you did not conduct any of these 4 studies, correct?
These particular 4 studies, no, they're not my studies, no.
Your Honor, plaintiffs believe that this witness is testifying outside the scope of epidemiology in which he is admittedly an expert. Plaintiffs assert that firearm violence is not a disease, disorder, or condition.
Thank you.
And that Dr. Siegel lacks foundation to testify as to these studies and asks that this witness be excluded.
Go ahead.
Your Honor, the witness has testified that he is a epidemiologist, that one of the subfields of epidemiology in which he has a particular scholarly record is relating to firearms violence as a cause of a disease or condition.
It's not.
Injuries are a disease or condition. He's published on this topic in 18 or 19 peer-reviewed journals. And regardless of the terminological quibbles about that, he is a scholar
Do you know
in the
the kind of
subfield that
bullshit
we are asking him
that they say
to
is
evaluate others'
peer-reviewed in
research in.
journals, you
He is entitled
fucking
to rely
moron?
on others' research. That is one of the entitlements of expert research is expert. And we have an extensive foundation that this is an ordinary component of the methods of an epidemiologist is to consult all of the studies in a particular area. He has done that here. And
he is an advocate
field of scholarly endeavor
for
in which
gun
he
bans,
participates,
is what he is.
and he is an expert in that field.
Your Honor, pursuant to Oregon Evidence Code 702, plaintiffs assert that this witness's training and education does not qualify him as an expert in the field of firearm violence. Epidemiology is firearm violence is not a disease, disorder, or condition. The injuries may be a condition, but the cause of the violence the witness just testified is not a disease, disorder, or condition. That is the study of epidemiology.
Okay, thank you. I'll overrule the objection.
Let's return to slide 2.
Jesus Christ, man.
I want to say something, though. I'm not clear, based upon what's being presented so far with the foundation. I don't know what a mass shooting or mass public shooting is by definition, by his definition. So I don't know that. I don't know. It's hard for me to understand this evidence without more context.
Yes, 100%, Sam.
How many, so you found 4 studies. What did those studies find?
Each of the 4 studies found that in mass shootings in which a large capacity magazine was used, there were more casualties than, and by casualties here, I mean fatalities or injuries. There were more casualties than in mass shooting events where a large capacity magazine was not used. And the magnitude of the difference was quite high. It was about a 2.5-fold increase in injuries. So
that's horseshit.
More than a doubling
YouTube.
Of the number
This is
of
a grit module. This is
when
not
you
a
have
gun.
a large capacity magazine that's used in a mass shooting.
And what?
How long does it take to reload a gun?
What is a casualty?
Casualty would be either a fatality, a death, or an injury, a non-fatal injury.
Did each of the 4 studies that you are presenting on this chart use the same definition of mass shooting?
Again,
Not exactly, no. I mean, the generally accepted definition of a mass shooting
shoot.
is based on the number of fatalities. Usually you have to have at least 4.
Yeah, that ain't
but the exact
saving
definitions
lives.
differed among these studies.
Having a LCN versus
Do the
a
differences
high
in the definitions used for mass shooting cause you to question the results of these studies?
No, actually, it's quite the opposite. The fact that you have 4 different studies all using somewhat different definitions of what is a mass shooting, and all 4 coming up with the exact same finding, remarkably close.
again.
2.2, 2.3, 2.6.
How did they collect the data?
These are
How
remarkably
did they
consistent
compile the
findings.
data? What
Those
metrics
argue
were they using?
for a conclusion that there is indeed a causal relationship here, and that the large capacity magazines are causing more casualties than
these
when
are
a non-large
rulers.
capacity magazine is being used.
Did each of the studies look at the same time period?
No, there was a variety of time periods here in the study as shown in the
Bang,
table.
bang, bang.
Did each of the studies
Bang,
use
bang.
the same statistical methods?
No, there was a variety of different statistical methods used among these studies.
Do the differences in the time period or the statistical methods used cause you to question the robustness of this result?
No, again, it's quite the opposite.
would
the
in
fact
any
that you
other
have 4 different
medical
studies looking
study.
at different time periods using different methodology actually gives me much more confidence that indeed this is a real valid result, and that there is a causal relationship between the use of large capacity magazines and an increased number of
No,
casualties
because you
in a mass
didn't
shooting.
take the same shooter with the same gun.
Do you have any other
with a high
basis
cap
other than
mag
these
or
4
a
studies for
standard
concluding
mag,
that this is a
let
causal
'em run a
relationship?
shooting, and then compare that against the same shooter
I
with
do.
the same gun.
I
with
also
a low
examined
capacity
studies
magazine.
that looked at the actual effects
There's
of
no way
large
to
capacity
compare these
magazine
things.
bans in practice across different states.
Let's bracket that evidence before, again, is there a way that epidemiologists generally try to separate causal relationships from spurious correlations?
Yes, there are a number of methods that are used to do
Well,
that.
they can do that because they're working with a disease.
Did you think
that
through
has
any
a
of those
certain
methods in this
path.
instance?
Yes, I
Oh.
focused on 2 of them.
What were those?
The first was the consistency of findings within a given line of evidence. And for example, within the line of evidence, which looks at the question of do large capacity
I'd like
magazines
to see
result in
John Locke
casualties,
take this fucker
I looked at these
apart.
studies in terms
piece
of how
by
consistent
piece.
is the evidence. And as I testified just a moment ago, the evidence is incredibly consistent among these 4 studies. The second methodology that we use is that we look at different lines of evidence to look at the same issue. So
Yeah,
this is one
Warsaw.
line of evidence to evaluate the impact of large capacity magazines, and that is looking at how many casualties they cause. A second line of evidence is a set of research studies that looked at the effect of large capacity magazine restrictions once they were put in place, and asked the question, do those laws result in a decrease in the number of, either in the incidence of mass shootings, the number of mass shootings, or in the number of casualties when a mass shooting does occur? And there's a body of literature that looks at that.
Do you also consider whether there's a plausible causal relationship?
Yes. And that is
Is it
the
just
third
me, or
major
does
part
this
of our
guy kind of
methodology,
look
is we
like
wanna look at,
Fauci?
is there a plausible conceptual reason why that
Because to me, he's got a striking resemblance to Dr.
Policy
Fauci.
would
with all his
have that
COVID
effect.
shit.
Is there such a plausible conceptual reason in this instance?
Yes, absolutely. As outlined by many scholars, including Christopher Coper, who's an expert in this area, there is a logical conceptual hypothesis, which is simply that when in the setting of a mass shooting, if a shooter has to
Objection,
reload.
Your Honor, lack of foundation.
For the love of God, that shouldn't have been your only objection there, buddy.
Objection
Come on.
foundation.
Your Honor, the witness is talking about he actually identified another scholar on which he was relying on. He's an expert. He's talking about the field of epidemiology and how they determine and separate causal relationships from spurious correlations. He said that the plausible relationship, and he was identifying the scholarly basis and scholarly work that he was relying on in his answer.
Have you provided these studies to Mr. Aiello?
We have, Your Honor.
So a conclusion by an expert is that whatever he was going to say. Is that what you're telling me is going to be his testimony? That he's affirming the credibility of that particular expert's conclusion based upon that one study?
I don't think that that's the only basis that he's going to provide. He's going to describe his own understanding and the reasons that he came to the opinion that there is a causal relationship between a large capacity magazine and the number of casualties in a mass shooting.
Again.
So the answer was interrupted. And so we are midstream in the answer to the question.
Well, it was direct. I mean, it was interrupted, but he was going to say.
I watched the sheriff deputy do a demonstration.
We don't know the rest of the answer, but that was one of the things he was going to say. And one expert's allowed to rely on another expert.
Your Honor, I'm not hearing any foundation for Dr. Siegel's firearm knowledge or expertise. I believe he's going to testify about reloading, and I haven't heard any foundation on that for Dr. Siegel or the study to which he's referring.
Well, yeah, an M1 shoot.
These are very much about the weight of the evidence, and Mr. Aiello is going to have an opportunity to cross-examine Dr. Siegel.
This bag always sticks. It's a little bit of a bitch. Go wind up damn doing something with this mag. But that's
I mean, what he just said to
That's
me
an unloaded
sounds
mag,
like
drops
this.
free.
You tell me why I'm wrong
It's a
or
loaded
how,
mag.
if I'm not wrong, it fits within 702.
I gotta find it.
What I heard him just say is, I've read Coper. He's an expert in the field. And I agree with him when he says, when his conclusion is X. That's what I just heard he was going to testify to. He didn't come to the conclusion, but did I misunderstand the nature and quality of that testimony?
That was one aspect of his answer.
It's a part of his answer that was just objected to. So.
I understand, and the rest of the answer was interrupted, so he wasn't able to provide the rest of the foundation.
I agree, but I'm just asking you on that section.
On that piece, yes, I think that and so
So then the question
By the way,
is,
that's the frame off my carry gun that I carry every
not
day.
being some type of vouching or comment on the credibility.
No
of
YouTube,
another
it's not a
expert,
gun.
which is clearly not allowed.
it is not vouching, it is reliance on others' work, which is permitted. We've heard historians talk throughout this trial about their review of other scholarly literature. So there's primary source material and secondary source material. He has done his own research. The next exhibit on the screen will be a study that he himself presented. The other pieces of his testimony, in part, are his reliance on scholarly material that has been produced by others. The background in the original component of presenting all of the other studies in the chart, before we even did that, we went through a foundation of what the methods that are used in the field of public health and epidemiology, which is to look at the totality of the evidence, not just the evidence that one person has assembled. I think that the testimony that we heard from Professor Tebeskov about there being a community of scholars that interact with one another and build on each other's ideas applies across academia, and that is part of his expertise. And under 703, the type of evidence that an expert ordinarily relies on in forming his opinions within his field of expertise is permitted. And the looking at peer-reviewed work and other work by other scholars is part of what epidemiologists do and how they form their opinions. And that's what he's doing in this instance, and in describing one of the bases of his determination that this is a causal relationship between large capacity magazines and casualties in mass shootings.
He's certainly entitled to look at other scholars, review that literature, and use it to come to his own conclusions. So I'm going to sustain the objection, because that's not what he was just doing. He was deriving someone else's conclusion from the data and saying, well, this is good data, and this conclusion is correct, which is different. And when Dr. Clavides was talking about the community of scholars, he's reviewing scholarly literature. That's different than adopting somebody else's conclusions. So I'm going to sustain the objection.
Dr. Siegel, when you were looking at the plausibility of this, of the relationship, what are the pieces, what kind of work did you do to come to an opinion about the plausibility?
Well, I reviewed the literature. I reviewed what academic experts have concluded, and came to my own conclusion based on that evidence, as well as my own study of the issue.
Did you look at any reports of mass shooting events?
Yes, I did.
Which mass shooting events?
Well, there were two in particular that I think demonstrate convincingly that when a mass shooter has to pause to change magazines, it is an opportunity for there to be some intervention, which puts an end to the shooting. And therefore
absolute horseshit argument.
The two events are, first of all, the Giffords shooting, the tragic shooting of.
Here it is. They use like one or two shootings.
In that shooting, the perpetrator shot 31 rounds and stopped to change magazines. And it was at the point where he stopped to change magazines where he was able to be tackled. And that put an end to the deaths. In the Poway synagogue shooting is another example where the shooter, in this case, did not have a large capacity magazine. They had a smaller magazine. They shot and killed a number of people. They too had to stop to change magazines. And again, the point where they had to change magazines, they were tackled, and that put an end to the shooting. So there is a very strong conceptual reason to believe.
No, there's not.
Limiting, that having a large capacity magazine would result in more casualties.
That does not, by any measure, meet the Brown and Dobbit standards. for expert testimony.
Thank
Two
you, dude. Wake
examples
up
from
over there.
events that happened around the country is not scientific testimony. That's a recounting of two events. You're going to have to do a much better job of laying a foundation under Daubert and Brown about how this is expert testimony, particularly when we're starting to talk about 4 studies. And I don't know. All I know is from the data dump that I got on the ORCP 79 proceedings that
I gotta clean my
the vast
damn
majority of
gun.
these studies look at the same events
Your Honor, plain,
through history, through time. And so if I've got 4, let me finish, sir. I've got 4
Ooh,
studies that are
getting
looking at the
snappy.
same 4 events and coming to the same conclusion about all 4 events. I don't know if that meets a scientifically valid basis for me to accept this as scientific expert testimony or just opinion evidence from somebody who's highly trained.
Opinion evidence from someone who's highly
I
trained in
need to do a better job of
epidemiology,
establishing
but
that
not
this
in
fits within
firearms.
Daubert, or I'm not going to. Daubert Brown, I'm not accepting it.
Who you talking to? What are you
So
doing?
if you'd like the page number and Kirkpatrick to work through that standard, it starts at 661.
Why are we canceling Thanksgiving?
Let me go grab my copy of Professor
Please do
Kirkpatrick's.
that. You know what? Why don't, I mean, yeah, go ahead. I mean, this is not, what just happened there is not
Yes,
scientific
everybody,
evidence.
my mother-in-law has
That's a
canceled
public
Thanksgiving.
policy
She's no
Analysis
longer on
about 2
Thanksgiving
events that
duty.
occurred. And
But
his
I am,
understanding
so-
through reports of what happened. I mean, it's hearsay. He's allowed to do that, but doesn't understand
Well,
how
I
it
don't
relates
base
to
turkeys
scientific
on Friday,
standards. So
so-
you'll need to show that to me
Because
with a lot more specificity. If that is the quality of the testimony you're intending to introduce through this expert.
Your Honor, when you say that you think that in your view, we're not meeting O'Kee and Daubert and Brown, are you referring to the specific answer there with regard to those 2 events, or were you referring to the study, the presentation of the studies as a whole?
Well, if this is.
Yeah, Mike,
the
I just saw
basis
that come
for those
through, brother. I'll
studies,
look at
the
it.
2 things that he just identified, which is the 2 he pulled when you asked the question, then I am absolutely considering the problem of the studies themselves. With this pause.
It's a new
link.
drug. It's not freaking crop.
It's not my view. It's what the law requires under the Oregon Evidence Code 702 to qualify expert testimony. And I'm not going to allow that to be the testimony of an expert because it isn't scientific evidence. If you'd like some time to think about it, I can give that to you, but we're sort of out of time for the day. If you want to take this up tomorrow and lay a better foundation than you've laid, I'm allowing you to introduce this evidence.
Dr. Siegel's available tomorrow.
It's fine.
If we're done for the day, then I can proceed
I'm not
now.
done for the day, but I'm not going to allow this quality of testimony, and I want you to be able to answer the question. You're a proponent
Same
for
to anybody else
a
that
ballot
judge is getting
measure.
a
I
little
want to allow
snappy.
you an opportunity to see if you can establish a scientific basis under Daubert and Brown. And if you are,
Because to
great.
me,
I'm ready to
And
continue.
Like
O'Kee, so go ahead. You go ahead and continue if you think you can establish that.
it seemed
that
like a little bit of a smack.
foundation. But I'm now in that mode before I allow any
He's
further
now in that
qualification of this expert.
Can we pull up Exhibit 153?
Oh, sorry, Dr. Siegel. I'm sorry if that hurt your feelings. You don't look happy.
Thank you. We have one for the
GT3, what's
court.
up, brother? We back at it. What we doing? We doing? We doing?
Take my gun off.
What you doing?
Take it off. It's on me.
Where's my son?
It's like on the floor.
Dr. Siegel, let's do this side by side if we can.
It's like Excalibur handing it over.
It's my favorite.
Gun if I want.
Footnote 1
I will beat you to death
for
with that one.
this study is the Journal of, I'm sorry, I'm jumping way past the foundation for this exhibit. What is Exhibit 153?
Like, it's
This is a table which is similar to the table that we discussed earlier. It's a table that shows the 4 studies that looked at the relationship between the number of casualties when a large capacity magazine is used in a mass shooting versus a non-large capacity magazine.
You want to come home? You don't want to stay with
This table adds the
And then he
references,
begged.
so it includes the
No,
references
it's
to the
not.
4
He likes
studies.
to come home.
Well, he does.
Did you see the video she sent?
I saw a couple of them.
Him writing?
Mhm.
Are there
That
other
was doing
peer-reviewed studies that you're aware of that study the same question?
No, I mean, I try to identify all of the studies in the literature that look at this topic. I don't exclude any. So there's no other studies that I'm aware of that looked at this issue. These are the 4 studies in the literature, and it's on these studies that it would be appropriate to make a judgment as an epidemiologist as to the answer to this research question.
Whatever with Papa tomorrow?
Yeah, I'm going to be running around swapping out stoves.
Okay.
Are these all studying the exact same set of events?
My mom's not going to have Ballot.
No, they're not. They're
That
not.
was one of the
The
reasons that she
events
went
are
in.
different. The number of events you can see are different. The definition of the events is different. So this is not just 4 studies that are rehashing the same
Don't
events
argue with
over and
Greg.
over again. Some of them are looking at high fatality events. Some of them are looking at mass public shootings. Some of them are looking at domestic shootings. And so there's a huge variety of events that are not entirely overlapping here.
Now, as far as getting Katniss from school,
How many
I
events
should be getting
did the
Katniss
Cooper
for sure.
study in
I told my mom that you should
2018
be.
evaluate?
We'll be back and forth with Papa. So just
In that study,
case,
there were
what is it,
47
next
events.
2:30? Or
How many did the
That'd be
Canon
cool.
study evaluate?
just in case?
There were 82 events. And we know,
How many?
I'm sorry, I was just going to say that we know that
No,
there was not a complete
Right.
overlap
Or a little
because
cabins ain't
the
gonna
Canon
work.
study included events that occurred from 1984 to 2008. None of those events were included in the Cooper study. They were completely different years of analysis. There's no way that those are all the same events.
And then the Dillon
It would be
2013
convenient to
study, how many
have-
events?
31 events there.
As a backup, just in case, like picking up kiddos.
So under the totality of the evidence,
Okay,
what
you
is your
wanna drive all the
opinion
way out there,
about the
okay.
relationship between the use of high-capacity magazines
She
and the number of
wants to-
casualties in a mass
She
shooting?
says she does not
Objection,
mind,
Your Honor, lack of foundation.
and I'm not arguing with it.
Don't argue with Greg there.
Don't argue with Greg.
That is a rule.
I'm objecting to the expert's qualification. All I'm hearing is that he read
Qualification, the
or
expert testimony.
the testimony. All I'm hearing is that the expert looked at other people's studies and has come to conclusions based on those studies.
He's entitled to do that. I
You gonna
do
crack a barrel
question
ribeye?
it's a little more specific
Some
than that.
dumplings.
Fried apple.
Doctor, you said that
Shit.
that these events were
Yeah,
actually
cheese
not
curd.
all mass public shootings. Some of them were high fatality events, which is different, and domestic shootings that are different. Is that correct?
No,
Do I
they were
understand
all-
that testimony correctly?
no, they were all mass shootings, but they occurred in different settings. In other words, some of them occurred in a domestic environment, some of them occurred in a public place. But they were all mass shootings. There were all multiple victims in these shootings.
So the titling on this slide that says number of casualties in mass public shootings is inaccurate. That's not what these numbers are specifically. Because they're not all mass
I
public
said
shootings. I
that
want to make
earlier.
sure I understand for the record.
They
Even
are
my
mass
wife
public
thinks
shootings.
this dude
They're-
looks like
they're
Dr.
mass
Fauci.
shootings that
Was it not?
No, it's not.
Well,
took place in
This dude
public.
is a
So, I mean,
doctor
The-
and does shit for every town.
they are,
for-
yeah, there is no,
Anti-gun
first of all, there is no
rules.
definition of mass public shootings.
whatever.
There's no definition. You can use those words however you want.
Okay.
So I'm just using.
I
those
heard
words.
I heard you testify that some of these were
Yes.
high fatality shootings.
Okay,
Some
okay.
looked at high fatality shootings. Some looked at mass public shootings and some looked at domestic shootings. And so I understood that to be a distinction, and you're saying that's not a distinction that you're making.
My apology, that was not, I was not trying to make a distinction between them. For example, a high fatality shooting is defined in some studies as a subset of mass public shootings when there are more than 8 fatalities. So it's a subset. These are all mass public shootings. These are what I was referring to was different subsets of mass public shootings.
So of these mass public shootings, how many of them are you saying that out of all of these mass shootings that you can identify 2 in which large capacity magazines were used?
No.
Of these mass public shootings that are identified, how many of them used large capacity magazines by percentage to the overall shootings?
It was between 60% and 80%,
Just
depending on the
about to
study.
text you this morning.
Use large capacity magazines
Exactly.
comparatively.
What was that, 9:30?
Exactly.
We didn't get pulled back till like 9:55. Fucking mad. If we were that late, we'd have to pay a fee.
Okay.
Yeah.
And I find that bullshit.
From the doctors, they don't give a fuck.
Go ahead, you can ask your
If
next
you're late
question.
for an appointment, doctors can raise hell.
Who authored Exhibit
If they're
153?
late for it, you don't get a
I did.
discount. Oh shit, polite society.
Does Exhibit 153 fairly summarize the conclusions of the studies listed?
Yes, it does.
Tell me we ain't raising that little girl right.
Defendants move admission of
Dog
Exhibit
is dying to
153.
Go to the gun shop tomorrow.
Can I go to the gun shop, please?
Hold on, because I'm going to post
Objection, Your
polite
Honor,
society
hearsay.
in the chat.
How is
She
it
wanted to help me work on that shotgun, but that one,
I believe
Brown and Sweet 16, that thing was like $1,800. No, maybe. Can't
70.
So
Well,
polite
these
society,
studies
they're
are
going to be at
out of
the-
court statements. Yes, he can refer to them
Oh,
as an
God.
expert, but that doesn't make them admissible.
whatever gun rights policy conference here. So Paul's doing
70.
live. So if you guys want to watch that one too. And yes, I'm posting other people's shit in my chat because they're all good.
703. Just because the facts or data
No, it doesn't take a village.
can be referred to,
Smart
but
ass.
the rule says
Actually not.
the facts or data need not be admissible in evidence. The author of
Chats and stuff,
these studies is not testifying.
those people, takes a village,
That's not a village.
a community, whatever. I don't like that word.
Okay, maybe it is hearsay.
May I be heard?
Yeah.
Under 702, experts are entitled to rely on hearsay. Under Rule 703, the witness an expert witness is allowed to disclose the basis of his opinion. Professor Siegel has already testified that he relied on these 4 studies in forming his opinion, that they're in fact in the scholarly literature, that there is a causal relationship between large capacity magazines and the number of casualties in a mass shooting. We're allowed to provide that, provide the basis of that, and we're allowed to provide it in summary form under 1006.
You're still a dead hole.
Bull fucking shit!
You're a bad hole.
Bullshit! You had half of my better.
1006 does not get around the
You
hearsay
did.
issue.
No, I did not.
It just says you can summarize voluminous content. 703, an expert can rely on hearsay evidence when forming the expert's opinion, but the facts or data need not be admissible
No.
in evidence.
Yes.
That's not an exception to the
I
hearsay.
have The normal
neither
definition
neither 703 nor
I have the
1006 are
wife's definition of
exceptions to the hearsay rule, except
I have the
as far as
normal wife's
admissibility
definition
of evidence. As far as Dr. Siegel's testimony, yes, there's an exception, but the admissibility of the study is not. It doesn't get around the hearsay issue there.
Your definition I had.
He's conveying the basis for his opinion
No.
through a table, and in combination, 703 and 1006 allow that.
I'm going to sustain the objection. I'm not going to admit it.
Did I tell you? I didn't tell. I don't know if I told you. You can't tell me that ain't Dr. Fauci.
See, that's what I said.
Or a cousin.
He's like a not too distant relative of Dr. Fauci.
Is it really?
No,
Okay.
not that I know of,
Could be.
but I'm just saying.
But anywho,
Oh,
we
shit.
were.
Another beer.
We did something. He worked on it, and then I worked on it. And we both fixed it. It was something like that. And he went, "Yay!" We did a high five. He was like, "Let's Eiffel Tower that bitch." And I didn't get it.
Yeah.
You made that face.
Let's look at Exhibit
So I was like,
143.
yeah. And he went, "You don't get the reference, do you?" I was like, "Nope." Like, don't look that one up.
It's another one.
No.
I don't have.
I did.
My apologies, sir.
Oh, well, there you go.
So now it's in the. Come on, let's go do it. Let's get this done. Let's Eiffel Tower this up. Okay.
It's more like a spit roast, but okay.
Hey, it's the little jokes that we have that keep us sane throughout the day.
Dr. Siegel, are you familiar with Exhibit 143?
Yes.
And one of them was like, no matter what you say to him, he always.
What
turns it
is
back.
Exhibit 143?
Yeah.
Yes.
This is an article that I co-authored that looked at the relationship between a variety of state gun laws
Can't win.
and their effectiveness
Then why do I
in
feel
terms
that?
of reducing the incidence or severity of mass public shootings.
I have no idea.
Which personality am I talking to right now?
Do you have a copy of Exhibit 143 available to you on your computer? If, or are you only relying on the screen?
I told you before.
I can retrieve it on my computer if you would like me
I don't give a
to.
shit, so you don't give a shit. We're never gonna figure it out.
I think that would be useful.
Right.
For a minute, I was like, what's happening? Yeah, dumbass, you gotta talk first.
I put a scope on.
Your Honor, plaintiffs object as outside the scope of the motion in limine. We don't have a foundation for the
You ever put
state
one on
gun
backwards
laws
and think, wow, that's a
referenced in
really
this
weird
study
scope?
being
that
similar
backwards.
at all to the so-defined large capacity magazine ban in Oregon.
And the girl
It
didn't
looks
notice it
like this
either.
is
She
a
brought it back
survey.
and
I
it's
have not seen a showing that the gun laws
Now look
surveyed
at it.
are similar,
Sure is.
identical
My bad.
at all to
Whoops.
ballot measure 114.
Because, yeah,
I
it took me a while
haven't
to
asked
figure it
the
out. I kept
witness
looking
any
through it. You could
questions
see
about
it.
his
It's
study,
hard to make that call.
and I have not
Okay,
moved for the
vertical?
admission of Exhibit 143.
Which you normally can't see those backwards, but you can see it.
Dr. Siegel, how is it going in trying
No,
to
dude,
find
I don't know
your?
who that
I've
is.
got it in
Bishop
front of
on
me.
air? I don't know.
Okay. What state gun laws did you examine in your study?
We looked at 8 different gun laws in this study, including large capacity ammunition magazine bans were one of those policies.
Did you perhaps look at Chicago
Can
with
you
all of their gun
tell me what the
control?
others were?
Yes, we looked at assault weapon bans. We looked at permit requirements.
Did you
We
look at
looked
the
at
federal
extreme
assault
risk
weapons
protection
ban?
order
The
laws.
government had to admit it had
We looked
no
at universal background check laws.
statistical effect
We looked
on
at
gun
May
violence.
issue concealed carry laws. We looked at laws that require the relinquishment of firearms by people who become ineligible to possess them. And we looked at violent misdemeanor laws, which are laws that prevent any.
Have you looked at prison where all of these guns and weapons
convicted of
and
a violent
knives and shit are illegal?
crime from possessing
People
a firearm.
still get killed on a daily basis.
You say that you examined them. What were you examining them for?
We examined them to determine whether or not they were effective in either decreasing the number of mass shootings that occurred in that state or decreasing the number of fatalities that occurred when a mass shooting occurred in that state.
And you're also still comparing gang shootings.
Were any
to
of the
spree
policies
killers.
effective?
Objection, Your Honor.
Yeah, I don't think you've laid a foundation for that.
Please, God. Just subject to every fucking.
I don't understand the objection. I apologize.
Fucking idiot.
Yes, so Your Honor,
Object.
Dr. Siegel's about ready to conclude that one of the
Object.
8
He's not an
policies, I
expert
believe,
in that.
was successful.
Object. He didn't write.
I suspect I know which one, but there has been no foundation that that policy has any similarities, identical, whether it's
Object.
identical,
If these laws
whether it's an
work,
apples to apples
why is the
comparison
federal government talking about
to
the
ballot
iron
measure
pipeline?
114.
And yes, you four-eyed
Beyond that,
mother.
I don't know anything about what techniques were used to make these determinations. I don't know anything about.
When you
the
look at a
potential
map, do you
there
see
with
people
regards to the
waving?
survey. I don't know about the existence of additional specialized literature that might have been engaged in making these determinations. I don't know.
Sorry, it was a really good line from a book.
The existence and maintenance of standards governing this type of determination. I don't know what type of safeguards were placed into
No, it
effect
wasn't, but I was
for the
just joking.
characterization of this
You gotta admit that
conclusion
line
that you're
is
asking
fun.
for without foundation. I don't know
Jesus,
the
Doctor,
nature and breadth of the
glasses are
inference
as
being
thick as
adduced
pickle
and how it
bottles.
comes to that.
When you
I
look
don't
at a
know
map,
the
do you
extent
see
to which
people
this
waving?
technique is accepted by scientists in the field that is involved with this type of survey of public policy decisions. I don't know any of that, and I'm not going to allow them to come to a conclusion scientifically on this record without you laying a foundation under Daubert and Brown. So go ahead, please. I'll sustain that there's no foundation. He objected. I didn't even wait for him to say it because I'm not going to allow it without a lot more being done to establish the scientific nature of this study.
I had to deal with that today.
Dr. Siegel, what method? How did you go about conducting the study that is in Exhibit 143?
We used a rigorous econometric technique, which is called difference in differences. And what one does is
I gotta grab another beer.
one does a regression analysis. The outcome variable is the presence or absence of a law in a state. And the regression method uses fixed year effects and fixed state effects. It uses a maximum likelihood method to estimate it uses a logistic regression analysis to examine the incidence of firearm, the incidence of mass shooting events. It uses what's called a zero inflated binomial model or a negative binomial model to analyze the number of fatalities in an event. And these methods are basically used to compare the differences between states with and without a large capacity magazine ban, which is defined as a ban on magazines greater than 10, with greater than 10 bullets in them. It's identical across all the states. There's no ambiguity about what these laws are. The number 10.
Dr. Siegel, I think you've answered the question about methods.
Yes.
So we'll address the others of the questions one by one. with respect to the data, are the methods that you just described commonly used in the social sciences?
Absolutely. These are very common. The difference in differences method is probably the most used method in evaluating the effect of public policies.
Are they commonly used in the field of epidemiology?
Absolutely. Again, even in epidemiology, this is the most common method to evaluate the effect of public policies.
Okay. How did you go about collecting the data that you relied on for the study that you ultimately published in Exhibit 143?
I took someone else's data and puked it
the
back
state
up.
law data we derive from legislative statutes. We went through the legislative statutes of every
cool
state
deal, Mike.
in every year and characterized each state as to whether it had the presence or absence of each of the 8 laws that I mentioned. The mass shooting data came from
Loosen up the damn belt. Somebody's pinching the shit
project that Northeastern University conducted, which was funded by the National Institute of Justice. And it is the largest and most comprehensive database of mass public shootings ever compiled.
Oh, you didn't use the trace?
Is reliance on that mass public shooting data, would that be common and accepted among epidemiologists in the United States?
It absolutely is.
Why so?
Because this was funded by the National Institute of Justice, which
we
is
know
one
they're
of
creditable.
probably the most reputable government agency that deals with these types of statistics. And it is the largest and most comprehensive database. And that's why many other studies are relying on the same database.
You can do some ghetto garlic bread.
Is coding state laws as being applicable or inapplicable commonly used method in epidemiology?
Yes, it is done all the time.
What about in other social sciences?
So you working Saturday?
Yeah, there are other social sciences which would also, I think, be interested in looking at laws and facts, and which would code laws based on statutes.
Applying those methods, how did you go about determining the conclusions in this study?
Well, basically using the methods that I talked about before, we generated regression coefficients. And those regression coefficients indicate what the impact of the law is on the incidence or severity of mass shootings.
More deadly than fentanyl. What the fuck?
Your Honor, you invited me to pause when I needed a break to become more prepared.
Mike, I still think it's funny you live in Beaver County.
In 2 seconds. If you're ready to break for the day, I am ready to break for the day.
Yes.
Your Honor, we, in terms of where we are in the progress of the case as a whole, we may or may not be able to rest by noon tomorrow. We will be trying to prepare to close.
I've heard about xylazine.
But that obviously will depend on what rebuttal case the plaintiffs intend to present as to whether or not that'll be possible to do on Friday. And so I think at this stage, we don't think it is wise to release Monday yet.
I wasn't going to release Monday.
Good deal, GT3.
Doctor, we'll start at 9 a.m. Pacific time. So eat your lunch beforehand. And we'll get through your testimony in our morning, your early afternoon.
All right, so we're going to be done for the day here.
Thank you. We'll go off the record till tomorrow then.
All right, so tomorrow, I'll kill that. Stop screen share. All right, so tomorrow ought to be a pretty interesting day with this case out of Oregon. Because, I mean, basically, they're going to have to finish up the majority of their case tomorrow. Hold on, G2. All right, that should be your in your inbox, G. All right, waiting on G. Let's listen to
And we think here, given that we
more where
know
that's at of.
that the state and the federal
Little
government
noise.
can ban automatic weapons like M16s,
Yeah, G,
and
you should have an
because
email
assault
for that now.
weapons are essentially M16s, we think that it could be a relatively simple case on that line alone. But of course, our view is also that we have shown, even though we do not believe it's our burden, that these are not in common use for self-defense, and also that they are consistent with the historical tradition of regulating dangerous and unusual weapons. So again, back to Judge Brennan's question, regardless of who carries the burden here, we believe that the state should prevail. And I would also note that this is at a preliminary injunction stage.
What's up, G2? G2, you're muted. Yes. G2, you're still muted. G2. Say hi.
Yeah, I was having
There you
audio. I was having audio issues. I couldn't hear anything.
Well, it's better than erectile dysfunction.
Right? So,
No, what's happening, brother?
did you hear the judge during that conversation with the doctor?
Which one? Because he kind of slapped that doctor a couple times.
Yeah, he did. But
Which
yeah,
is,
this
I like
this
to see.
so this judge is out of Harney County, which is the southeast corner of Oregon, almost bordering like Nevada, California.
Yeah.
And he's pretty close to being a constitutionalist.
Yeah, because I mean he did pretty good in the oh, give me a second, baby, and I'll get something. He did pretty good in the initial injunction.
You know I can open Piscata.
Hold on.
Just wait.
He did a temporary injunction, and then he did a permanent injunction, and now we're dealing with, and the permanent injunction still standing until the trial's over. And he's already stated that if the state appeals the decision, whatever the decision is, that he'll put it through until the trial is over in the state Supreme Court.
Well, let's look at something real fast. Let me bring this over. So this is the good doctor. Like I said, this is an older picture of him. He's younger, but look who he's working with. Everytown.
Yep.
Spelling common myths about gun ownership and gun culture.
Yeah. The thing is this whole testimony is going to get stricken. Watch tomorrow after he gets done testifying, because they've already laid the foundation. And so everything he's been talking about is based on other people's studies. So it's not like anything he has done. So it's all going to be hearsay. And that's what they've been saying is, hey, this is just hearsay. He's not.
I mean, this dude, he's compiled or went through a bunch of other people's studies, but there's still no testimony as to the validity of those studies, how they compiled the numbers, how they correlated everything. And see, let's see this.
And
Let me back this up.
and the thing is it doesn't really matter because at the end of the day, do these 10-round magazine laws date back to 1791
No.
to 1861?
Well, and see, that's going to be because, and we have to do a couple things. One, we have to realize that this is just in state court right now, so they haven't talked about a lot of the federal stuff yet.
So, the federal case for this ballot measure 114 has actually already been heard, and it's already been appealed to the Ninth Circuit because that was Judge Karen Immigrant or whatever her name is, who is a stupid liberal piece of shit. Who, I mean, if you read her decision, oh my God, you'd be like, what the hell? You can't even understand her decision.
Yeah, we looked at that. Well, I looked at it not too long back after that initial temporary injunction. But see, we're still looking at, again, here we're still looking at state. So this is going to go to the federal courts more than likely after this. Because if this judge shoots it down, we know that the state's going to appeal it.
So
I mean, they're not going to let that stand. And if the judge affirms all this, well, that gives a place for Second Amendment Foundation, Gun Owners of America. The NRA might actually get off their ass to push this to federal.
This case here actually, the GOA, the GOF were a part of this case at the beginning, and then they filed a motion to be removed from the case.
Did they file a motion to get removed?
Yes. I didn't
know that.
The GOA and the GOF both filed motions to be removed from this case in Harney County. And so the SAF, what's the Silent Majority Foundation out of Washington State?
Yeah.
And the FPC are all a part of the ballot measure 114 lawsuit that's already been decided in the Portland federal court, which has now been appealed to the Ninth Circuit. So depending on this one, I can almost guarantee you the judge is going to rule the same way he's been ruling. And so the state will have to then appeal it to the state Supreme Court. And if the state Supreme Court stays with the way they've been, they have shot down every attempt to get the TROs removed.
Yeah.
And they said, no, you're just going to have to deal with it through trial. And I know because I couldn't really type or talk a lot when this was going on, and some people were asking. I know Kurt24 was asking earlier. So ballot measure 114 deals with 10-round mag capacity, but here's where a lot of people don't understand. Not only does it deal with the 10-round, but it states in there that they cannot be easily or readily converted back to.
Yeah.
Except more. So that means you can't even get the California compliant magazines, because even if you rivet them, that rivet can be drilled out.
Oh yeah.
And so this kind of stuff has already been testified to and everything. So pretty much the only thing you'll be able to have is the old GI 1911 magazines that actually are a solid one-piece magazine.
Yeah.
So any other newer magazine, even your Glock 43Xs that come with a 10-round mag, because that base plate can be popped off, an extension can be put on there, those will be illegal.
Yeah. Let's look at something real fast. I buzzed through this briefly today, and this was I think from day one where they were going through witnesses, and this dude is absolutely ecstatic at the way they treated a witness that was against the government's order. And you may know these cats, G2, since you're up there, KGW News.
Yeah, so this is news that's over on the eastern side of the state, so which is a lot more conservative than the western side of the state. And so if you break the state down, at the very tip of the state, from I-5 west over to Astoria and down to Eugene, is pretty much all your liberal controlled areas.
Yeah.
Which actually controls it controls the entire state because of the way that's laid out with the populace.
Yeah, that's your bigger cities and stuff.
So if you go Eugene south to the California border and east of Eugene, all the way up from the top of the state. So if you were to divide, just cut out that one corner of the state, the rest of the state is completely conservative. Yeah. And if you look at the way the original portion of who wanted to leave the state, it would have left that little square top corner. Everybody south of Eugene and east would have gone to Idaho, or you go back a little further than that, they wanted to form the state of Jefferson, which was eastern Washington, all that portion of Oregon and northern California would have then compiled to make the state of Jefferson.
Let's look at this real fast, because I think this was a story. Yeah, this was after the first day.
So this was after Monday.
Yeah, this was after Monday.
I'm gonna try to file some FOIA requests to get the all the court hearing.
Hell yeah, dude.
Video from day one to through Friday, so that I can put it up on my channel.
Yeah.
Yesterday, Dick Heller actually testified.
Oh shit, yeah.
And so I'd like to be able to really listen to that. I got to catch bits and pieces of it because I was at work. So
dude, I want to be able to watch all of this from day one all the way through, and be able to basically do like we do, share the video, let everybody watch it. But the way they're doing it over freaking whatchamacallit for a meeting, it's really honestly and truly like they don't want everybody to see it. It's like, we're gonna make this a little extra harder.
So if you actually look during that the where they're sharing that link I sent you, there's on average about 250 to 400 people that are in there watching that.
Yeah, I saw that today. Let's look at this and let's
Today, the state trial regarding Oregon's gun control measure, that's 114, got underway out in Harney County. We're going to dive deep into this issue as well as little pieces of the trial that you're not going to see or read about almost anywhere else.
Well, that's the problem. Not see or read about. Why not make it to where this video is accessible to everybody, and you can go and watch it and not have to have their stream codes?
Make sure that we're all on the same page. Measure 114 requires people to get a permit before buying a gun. And to get that permit, they have to go through a criminal background check and a gun safety course. The measure also bans what it calls high-capacity magazines, which hold more than 10 rounds of ammo. Measure 114 has already been found constitutional in federal court. So that means it does pass the muster of the U.S. Constitution, according to one judge. But this state trial is the reason the measure has not been implemented since voters narrowly approved it last November. And here's the big issue that is going to be answered by the circuit court judge in Harney County. Is Measure 114 constitutional as it applies to the Oregon Constitution? No. Here's the exact wording of the state's constitution that's being considered. It's Article 1, Section 27.
Okay. So this is the wording of Section 27. I posted that in the chat earlier. Is there anything in here that says that the government of Oregon can control the arms that the people own?
No.
Is there anything in here that says the people of Oregon can own these guns except the guns we say they can own?
So if you read it and you listen to it, it actually goes further than the federal or our constitutional rights in the Second Amendment. It actually gives it to the people and tells that the the guards or the National Guard is subservient to the people.
Yeah. Well, you read this. Okay, this Oregon Constitution, Section 27, said, I posted in chat earlier, the right to bear arms, military subordinate to civil power, which is normal. Any of our military should be subordinate to civilian power. The people shall have the right to bear arms for defense of themselves and the state, but the military shall be kept in strict subordination to civil power. So there's nothing in there that says the government of Oregon, has the right to dictate which arms people can own. And when you're dealing with legal documents, which is what this is, that means that the meaning of the words and the words that were agreed to when that contract was agreed to is what matters.
So, and the thing is if people actually pay attention,
that's the big problem.
If the governor ever declares martial law, then it's not the National Guard then has to revert all their decisions to the people, not to the government. Yeah. They actually have to then go and ask the people what to do.
Let's listen to this, because this dude I breezed through this earlier, and I could be wrong, but I breezed through this earlier just clicking through shit, and he sounded like a smug prick who agreed with the government's case. So let's watch this.
7, if you want to look it up yourself. Right to bear arms, military subordinate to civil power. The people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civil power. That's it. Pretty simple, huh? The judge has already said that he plans to rule only on the language of the measure itself when it comes to how it applies to the state constitution. He will not make a ruling based on how the measure could be implemented in the future. And that is a big deal because there are still plenty of questions on how this could play out if it's found constitutional. But that does not matter this week. It's all about language this week. The trial is scheduled to last 6 days, though the judge said it may not go that long because he restricted certain testimony, again, to only focus on the language. Today, the judge heard opening arguments, and the plaintiffs, those are the people who want to throw 114 out, they called witnesses. They also get tomorrow to do that as well. Then the defense, that's the state, will call witnesses Wednesday and Thursday. Friday and Monday are the extra days in the case the testimony runs long. But before opening statements could even get underway today, there was a moment in court that we think is pretty important to highlight. It shows that even though these are incredibly heated, partisan, tough issues, we're all human.
I received your trial memorandums on the 13th and 15th. I'll be frank, I haven't had a chance to really process everything that's in them. I looked over each of them, but haven't had time to really process all the information. It's a lot of pages, and it was my daughter's birthday this weekend, so turns out that takes priority.
Well, there you go. That's right. Each side submitted memorandums or outlines of their cases late last week, but the judge had his daughter's birthday to focus on. Anyway, let's get to some of the opening arguments, starting with the plaintiffs, the people who do not want 114 to take effect.
Plaintiffs will show that Article 1, Section 27 of the Oregon Constitution protects the individual Oregonians' right to bear arms in defense of themselves and the state. Article 1, Section 27 was ratified as part of Oregon's original constitution on November 9th, 1857. 164 years, 364 days later, on November 8th, 2022, ballot measure 114 was passed.
Yeah. Again, we looked at the text of it, and it does not give the government any power to regulate arms.
Plaintiffs contend that ballot measure 114 represents the most significant threat to that right Oregonians have faced in nearly 165 years. Your Honor, this case is not about public health, public safety, or public concern. This is about individual rights. This is about the individual right to self-defense and the right to bear arms to secure that right. This case is about how an individual right will fare against the might of the Oregon state government. Plaintiffs contend that this question was answered 165 years ago.
All right, so there you have it from the plaintiffs. Now let's hear from the attorney representing the state, hoping that they can implement Measure 114.
Evidence in this trial will demonstrate that Measure 114 was a reasonable legislative response to the public safety concerns posed by firearms. The testimony of defendants' experts will demonstrate to the court that large capacity magazines increase the number of firearm homicides and the frequency and fatality of mass shootings. That large capacity magazines were not in common use for self-defense in the 1850s.
Yes, it's the same way V8 engines weren't in use then.
That modern firearms bearing large capacity magazines do not have it.
Because if you want to be technical, there was tubular magazines dating back to the 1760s, which in day 2 of this trial they talked about. And they talked about other firearms, even detachable box magazines that came out in the early 1800s that accepted more than 10 rounds.
Yeah.
And so, and the thing is like with this, the guy that was talking, the news anchor.
Yeah.
So it will require a permit to purchase a firearm.
Mm-hmm.
Now, in that permit to purchase, it requires a background check.
Yeah.
How are you going to run a NICS background check, which the federal government has already, the FBI has already told the state, you cannot use NICS to run a background check for a pistol purchase permit. It has to be on firearms only. And so, along with the wording of it, like, you and I could go to the range
Yeah.
right? I can loan you my firearms there at the range.
Yeah, that's a transfer.
But if we go to the class and you say you don't have a firearm, I cannot loan you my firearm so that you can then qualify during the class. You have to have a firearm to be able to do the live shooting portion of that.
So how do you get a firearm when you can't purchase a firearm?
Exactly.
Yeah, that's the way it's set up. New York was like that. And there was another state that was like that. California's one. You know, you can't and like in New York, I couldn't, if I wasn't a New York resident with a New York ID and all this bullshit, I couldn't walk into a gun store and have them hand me a gun so I could inspect it to see whether it was one I wanted to buy.
So in California, you don't have to have a purchase permit.
Yeah.
They do require a 10-day wait from the time you purchase. So even if the background check comes back, you have to wait 10 days.
Yeah.
To be able to take possession of it, which that will go away too, because that's going to be ruled unconstitutional.
Well, yeah, you would think, but I mean, even with Bruin, here's the biggest thing. Even with Bruin, which basically showed all of these gun laws are absolutely unconstitutional. These people will just keep making these retarded ass laws, and then we have to keep fighting them in court because there's no downside to them. There's no penalty to them.
Nope. And that's what we need to take and actually introduce laws into effect to remove them from office.
Dude, I would like to see laws put in place, kind of like a loser pays, to where if the government brings you to court, they charge you with something, and they run you through the court process. If you are found to be not guilty, then the court should have to pay for all of your legal costs, all of your pain, all of your suffering, all of your lost wages, all that shit.
Yeah, but the thing is the government's playing with house money. They're playing with taxpayers' money.
100%.
So if they lose and stuff, all they're going to do is raise taxes.
Yeah. They'll print more money. They don't care. It's you know, they can spend $3 million prosecuting your ass because it's not coming out of their pocketbook.
What we need to do is take away their immunity and everything from each of the politicians, and if they sign on to a law that's then deemed unconstitutional, that every single person, every single representative that has signed on to that law and voted for that law then has to pay out of their private pocket to reimburse both sides.
Yes. Dude, I would love to see that. I tell you what I'd really love to see. Like I said, I'd like to see it where if the government prosecutes you for something and you're found not guilty, they pay all of your legal fees, they pay all your restitution. But I would also like to see where if, say, these gun laws, so you're caught for having a machine gun, you're sent to jail for 10 years. All of a sudden, that's found to be unconstitutional. Anybody who supported that law ought to have their ass put in fucking prison for the same amount of time that everybody else was put into prison for. So if you support that law, your fucking nuts are on the line.
And make it so they can never hold office again.
Oh, yeah. Yeah, they ought to be stripped from office. They shouldn't be allowed to be a fucking school crossing guard at that point.
Any relevant 1850s counterparts
Okay.
that large capacity magazines are rarely used in self-defense, that the permit to purchase is a reasonable public safety measure, and that any time restrictions contained within it are consistent with the historic exercise of the right to bear arms. At the close of testimony, Your Honor, we will ask that you find Measure 114 is constitutional under Article 1, Section 27 of the Oregon Constitution.
Now, following those opening arguments, the plaintiffs called witnesses. And one of those witnesses included a man named Derek LeBlanc. He's a firearms instructor who owns his own training company. Before the state cross-examined LeBlanc, the trial was delayed so the plaintiff's attorneys could show text messages between himself and LeBlanc. The state was trying to show that LeBlanc is actually a gun advocate and not an independent expert. They cited a blog post that LeBlanc wrote during the federal trial on Measure 114. Take a listen.
You said here that you planned to help our attorneys. Is that true?
I think you're taking words out of context and you're trying to use them against me. And that's not the point of this blog post. This blog post is to educate gun owners to understand, what we're all up against with Measure 114.
And did you do work to help the federal attorneys?
No.
But it says here that you were working to help our attorneys, and you testified earlier that it was the federal attorneys that you were helping.
Well,
correct?
the way I look at it is I'm on a team, and it's my team against the other team.
Yep.
Just like.
Gotcha.
Okay, so for people who don't know who Derek LeBlanc is, which is the guy who's testifying right now, he has a foundation called Kids Safe, which I've interviewed him on my YouTube channel.
Yeah.
And everything. He has a great organization teaching youth about firearm safety and stuff like that. And so they're trying to discredit him right now in this and everything. And he, they're trying to say that
they were trying to say he's an advocate. He's not an expert. And that's where I caught this earlier. And that's why I said the dude giving this news segment seems like a pompous ass, because he was all happy about the fucking state destroying this witness. And you'll see that in a second, which makes me think this dude hadn't been punched in the face near enough.
Like you're on the opposite team of me right now.
Interesting, don't you think? The state attorney then asked LeBlanc if the plaintiff's attorney had told him about the questions that he would ask him during today's trial.
Did Mr. Aiello tell you that the 11-page document outlined the answers that he was looking to get in your testimony today?
Can you repeat that, please?
Sure. Did the 11-page document that Mr. Aiello sent you outline the answers that he was looking to get from your testimony today?
Well, we were, that was part of our conversation. We were just kind of spellbound. This is my first time here on the stand in this regard. And so I'm ultimately scared. I'm just an average guy that I was just looking for what this looks like, right? So I could wrap my mind around what I needed to do to prepare.
Did the 11-page document that Mr. Aiello sent you outline the answers that he was looking to get from you?
No.
Ouch. So the state attorney submitted a document as a court exhibit and then asked LeBlanc to read part of the second page.
On the third line, did Mr. Aiello write to you, "I've outlined the answers I'm looking to get"?
It's there, yes.
This is what you call taking apart an expert witness. The next.
See, that's where I said this dude's fucking. He's all happy. Well, the state was taking apart this guy's witness. Now, wait a second. The guy that state's having testify is part of fucking every town, but I don't see you going after him for being this fucking shit.
Next part of the questioning from the state was having LeBlanc confirm that he previously pleaded guilty to 2 counts of contempt of court in Lane County earlier this year in an unrelated case. Quite the cross-examination on day one. We'll see what tomorrow brings out in Harney County.
And so when they say Lane County, so that's Eugene. And that is where Kids Safe is actually located. It's in, Democrat controlled area. And if you look at some of the stuff, he has gone to Hawaii and has, he's growing the Kids Safe to be, and they now have a chapter in Hawaii. I believe they got one in Washington and I think California. And I know that they're talking about trying to go east and be able to get more of these chapters teaching kids firearm safety and what to do if they find a firearm, yada, yada, yada. And so, yeah, he's a really good guy.
Yeah, dude, he sounds like it.
And like he said, I'm just an average guy.
All right, baby. Let me give me a second. I'll give you that. So let's look at this real fast. This is something Warsaw sent over, and this is about the whole New Mexico governor and her BS. Hey, baby.
I'm trying to look at solutions to address the gun violence directly and not be overshadowed by a court order that is not going to be enforceable. I'm telling you that right now. It's going to waste our time. I want to make sure that we have real solutions to battle the gun violence.
So that was the sheriff of New Mexico's most populous county responding last night to the governor's controversial gun violence order, calling it unconstitutional. Governor Michelle Lujan Grisham last week declared a public health emergency and announced a 30-day ban on carrying firearms, open or concealed, in public areas.
You think she is wearing the same outfit during Biden's red speech? She's got the nice little red sleeves on, black outfit. Just saying.
In Albuquerque and its county, she issued the emergency order after the shooting deaths of 3 children this summer. That includes an 11-year-old boy shot and killed outside of a minor league baseball stadium just last week, as well as mass shootings in the state. The Democratic governor's move is facing pushback from law enforcement officials and gun rights groups. At least 2 organizations have filed lawsuits arguing that it violates the Second Amendment. And over the weekend, some New Mexicans openly defied this mandate during a protest.
That's what we should
We all agree that the governor has overstepped her authority and is actually in violation of the law.
I don't know what her thought process was that she suddenly thought she could trample the Second Amendment.
Joining us now for her first national televised interview since issuing this order is the governor of New Mexico, Michelle Lujan Grisham. Governor, thank you for your time this morning.
I've actually seen this part.
Yeah.
And it's actually funny when you listen to this. Really pay attention to the news anchor.
Oh, yeah.
Because she's going to destroy the governor.
Oh, well, that's going to be funny, especially on CNN.
So, yeah.
Exactly that. We just heard from the sheriff. He joins the attorney general and others who say they won't enforce it. It's unconstitutional. Why do it if it can't be enforced?
Well, that's their opinion. They have no bold actions. They don't have any plans for reducing gun violence. Every single aspect in terms of preventing gun violence, funds, crime labs, more than $150 million for retention bonuses and recruitment of new police officers. I'm focused on one thing. We have the 3rd highest gun-related injuries in the country, 90% higher than the national average. We lost 143 children between 2017 and 2021. It is unacceptable, and it calls for immediate and swift and bold action. And frankly, the evidence bears out over and over again. Fewer guns on the streets makes everyone safer, and I'm focused on everyone's
The evidence has never pointed to that. Less guns, well, less people get shot. Yeah, but more people get stabbed and beat to death with fucking bats.
Constitutional rights, not just those the NRA says I should be focused on.
Yeah, it's not just the NRA. Here's one other concern from the sheriff. Here's what he told my colleague Caitlin Collins last night.
In a couple of months or a year down the road, we're the ones stuck in court, and we're the ones getting sued over all of these infringement of rights and all these other court battles, when I could be focusing so much more on crime.
Has any law enforcement officer in Albuquerque or the county actually enforced this yet?
Well, we haven't issued any civil penalties, but that doesn't mean that we're not and that we don't have the ability to do that.
But that's a no, right?
This is the pushback I get from every single, well, it's a no this minute, but that doesn't mean that we aren't, and it doesn't mean that we don't have additional police presence. And if not this bold action, making sure that you're safe going to the grocery store, you're safe going to a baseball game, you're safe walking on a hiking trail. There are individuals, including young people, where it's illegal today to have a handgun, openly carrying handguns. My question to law enforcement is, where are you? Where are you? In that young 11-year-old, Froylin Villegas, 17 rounds were fired into that gun. 35,000 rounds are fired at least annually in Albuquerque alone. You are not safe going to work, getting your prescription drugs, or going to a public park. And it wasn't just about a cooling off period. It's about making sure that everyone is safer while we do bolder work to get at both the drug epidemic and the gun violence epidemic. And it's not for police to tell me what's constitutional or not. They haven't supported not one gun violence effort in the state of New Mexico, including domestic violence protections, universal background checks. And I know you want to ask me a question, so I'll take a breath, but these are NRA talking points about their rights and not about anybody else's. And it's not a ban. It's a temporary pause so that we can make this community safer.
Oh, no, your temporary pause, lady, was written to where you could extend it at will and just make it permanent day by day. Bitch, please, some of us can actually fucking read.
Just like she did with the COVID mandate.
Yeah. And people who believe this ignorant hoe bag, I swear to God, just need to be. I can't say that. Can't say that. We're gonna listen to this. Can't say that.
I hear you, and I'm glad you mentioned Froylin Villegas' name. 11 years old. Also in July, you had Amber Archuleta, 13 years old, killed. You had Galilea Samigo in August. I want to mention those names because those are kids. They're kids who shouldn't be shot. But we also have, Governor, the Constitution of New Mexico and the Constitution of the United States, and you're an attorney. Do you think you're on solid constitutional ground here?
Well, we're going to see. I mean, look, I wouldn't do it if I didn't think I had the right. I have the right.
Where is the right? Where is the right?
State of New Mexico. Public health, it's a suspension. It's not a ban. And we'll see what all of these court actions do. And I did say publicly, Poppy, look, I got a Supreme Court that says my personal bodily autonomy can be restricted. And yet NRA and other issues, the Second Amendment keeps getting broadened.
She keeps going back
the Bruin case in New York.
SCOTUS said that they can, she keeps going back a lot. This is her argument to the CNN reporter. But SCOTUS said that they can restrict, abortions. So I should be able to restrict the Second Amendment. Well, one thing, you dumb cunt, abortions were never in the Constitution of the United States.
No. I'm sorry. You don't have the right to murder a child in your womb, just like I don't have a right to murder someone at the gas station because they annoy me.
Or because somebody got the gas pump right in front of you, and you have to wait 5 minutes. No, you don't get to shoot them and say, "Hey, I'm moving your car out of the fucking way so I can fill my car. Just because I got a gun and you don't, yeah.
Yeah. Dude, I'm sorry. If I shot everybody who annoyed me, I'd be home at the end of the day with an unloaded gun with a pile full of fucking unloaded brass.
Yep.
I don't get the right to shoot people, murder people because they annoy me. You don't get the right to murder or have someone. Here's the deal. You don't get the right to pay someone to murder your unborn child because it's going to be an inconvenience for you. I don't get the right to go pay someone to murder people because they're an inconvenience to me.
Exactly.
A life is a life. Hoe bag.
And cases in Texas
and that's
that say
actually,
you can
Governor,
be
what
a,
I'm talking
a
about.
drug
You bring up the Bruin case. The
But I
Supreme
don't
Court
know.
last
This
year.
question-
Let me
but
just
yeah.
ask you this, because the Supreme Court last year
sure.
totally changed what we're allowed to do, what you're allowed to do. And they said, unless you can base it in the history and tradition, you don't have grounds to do something like this. The New Mexico Constitution, I looked last night, Article 2, Section 6 says this, quote, no law shall abridge the right of citizens to keep and bear arms for security and defense. No municipality or county shall regulate in any way any incident of the right to keep and bear arms. Are you not?
So nothing in there, I'm pretty good at reading, says the government has the right to dictate which arms people can own, where they can own them, and how they can carry them.
Violation of both the U.S. Constitution and your state's Constitution?
I don't believe that we are. And if that narrow reading of the Constitution, which has been tested in the state, we wouldn't have universal background checks. We wouldn't have a way.
No, the fact is, you shouldn't have universal background checks.
And and the thing is your test that she's touting happened before the New York Pistol and Rifle v. Bruin decision. What if that would be retried today? Then that universal background check that she's so proud of would go bye-bye, just like her little pipe dream of
if the courts actually held to the ruling, it would go.
Well, the only time it's ever been challenged was like pre, New York Pistol Rifle decision. Now, if it would be re-challenged, it's going to go bye-bye. And then what's she going to cry about?
Oh, everything. That's the answer. Everything.
Now,
and is she wearing a necklace big enough that Flava Flav would be jealous of?
Oh yeah,
I just saw that. Sorry,
if it had a clock on there, he'd be like so jealous.
Oh yeah.
Period. We wouldn't have a red flag law. We wouldn't have prohibitions for straw purchases. None of those would have been deemed constitutional.
Okay, prohibitions are federal. They have been there since 68? Did they come about in 68 or 86? Either way,
so
it's been illegal for you to purchase a gun for someone who can't purchase it for a very long time.
So, the 68 Gun Control Act, but it wasn't until the Brady Law in 96 before they actually ever started doing 4473s.
Yep, 100%. Yep.
So you're talking from 68 to 96, you were still able to buy firearms and no one knew if you were a felon or not.
Well, I mean, let's be more historic about this. Since before the country was actually founded until the Brady Law in the 90s, the government didn't do a background check on your ass to see whether you could own a firearm or not.
Yep. And here's the thing. So if you go back and you listen to 114, that's on my on my YouTube channel.
Yeah.
It was back in December, maybe it was January, when we had the last 8-hour trial portion of it. And this is the same reason why they didn't recall the state didn't bring in their historical guy from Berkeley.
Yeah.
He was actually more, with everything he testified to, it supported the plaintiffs. And in his testimony, he stated that most firearms in America at that time, from 1791 to 1861, were homemade firearms.
Yeah.
That more people made their own firearms than were actually, having manufacturers like a Glock or Colt or Smith and Wesson or any of these, Henry. Most people manufactured their own firearms that they were using to defend their home, their country, their state. So you take and you use that same to, that testimony can then be used to destroy the frame and receiver law.
Oh yeah.
Or it's not even a law. It is an opinion based on from the ATF.
And I'm gonna do. I've got part of it, but I'm gonna do a live stream. If I do it tomorrow night, I might do it tomorrow night. If not, I'll do it another night. About this next ruling from the ATF, and we're gonna get together and we're all gonna write a letter on the Federal Registry against this whole gun dealer rule. Which ought to be a fun one because we're going to be as much of a smart ass as we can be.
And today, all of them are.
They were before
These
the Supreme Court
right
ruled
discussions. Fair, but they haven't been tested again.
Did you hear that?
And
Did
so
you hear?
for law enforcement, and I understand they're not really. Look, if you want the community to be safer, show me that you can do that. If you're not going to stand up for these kids and really test as hard as you can, getting fewer guns and dealing with gun violence in a meaningful way, then you're basically saying that you won't be responsible to protect the citizens of the state. Well, I will, and I will do everything in my power to turn the tide and to make sure every New Mexican, particularly children, are safe.
To law-abiding citizens, gun owners in your state, I think they're wondering this morning, is this more about making a statement
off of CNN
than about enforcing this? I want to play for people an exchange you had with a journalist at your press conference last week. Here it was.
Do you really think that criminals are going to hear this message and not carry a gun in Albuquerque on the streets for 30 days?
No. You said no. Are you going to keep doing this? 30 days, take it up to the Supreme Court? Or is this about a statement right now?
No, listen, I can make any number of statements and already have. In 2007, I was very clear about where I stood in my initial congressional race about gun violence. So this is nothing new. But the rates of gun violence in my state, third worst in the nation, are absolutely unacceptable. And while I see that it is getting more challenging to find strategic efforts that keep everyone safe, that doesn't mean I shouldn't do them. And it's not the only thing in the order. It's about public places. It's about making sure we don't have guns at schools. It's about testing for fentanyl in wastewater at schools and other areas where I think that we have a growing problem.
To be clear, in your executive order, you're right.
I mean,
Only
it's not
one
just
part
that.
of this is being challenged by the courts. You try to do a lot of
That's
other
right.
things. I'm glad you mentioned that. Just let me ask you one final question about executive power, right? That's a big thing you're testing here too. Are you overreaching? Let me give you a hypothetical, right? You're a Democratic governor who's doing this. What if a Republican governor of a state declares a health emergency and unilaterally outlaws abortion in that state, where the legislature has not done so by statute?
Question.
Following your logic, would that also be sound?
In this situation, honestly, I don't think so. But that is what's happening in this country, is that we've got extremists on this question and on reproductive rights. And the issue about the emergency order, the difference
How is
here
abortion
is I had an
even termed as a
11-year-old
reproductive right?
that was shot and killed with 17 rounds in a road rage. I got a call from a surgeon whose husband was killed in the exact same way in Albuquerque. Violence is growing. Every single investment and strategy.
Hold on. Wait a second. So she got a call from two people talking about guns were used in the murder of their loved one. I'm pretty sure I can look at New Mexico and I can go find the statistics for people who were beat to death, choked to death, knifed to death. And I don't hear your ass talking about that. Yeah, hit with cars. I don't hear your ass talking about them, bitch.
Including a bold call to action, has failed. And here, this is about protecting everyone's rights. The Republican governor is about restricting some rights. I think we're going to see these challenges across the
Abortion
country.
isn't a right.
I'm going to stand up for the children.
No, there is nowhere in the United States Constitution, in the Bill of Rights, that says that a woman has the right to pay for somebody to murder the child in her womb. There's nothing that says that. It does, however, say a militia being necessary for a free state, right of the people, keep and bear arms, shall not be infringed.
And I'm going to stand up for public safety in Albuquerque.
We will watch as you do, and I was asking about the law itself and the reach that you have under the Constitution of the United States and New Mexico. I'm glad you came. This is a really important discussion. Please.
I will be willing to bet it has been a long time since she came. I'm just saying.
Come back anytime you'd like to continue the conversation, Governor Grisham.
Bernie, what's up, brother? I didn't see you come in.
Thank you, Pop.
Bro, what's happening? Yeah, there's an awful lot.
Good evening. I'm Jeff Bennett.
There. And look, the tactical turkeys are kicking, so I'm going to get my happy ass out of here. Let me post it again. Tactical turkeys are up. You guys come over to the turkeys. Let me make sure I'm getting this right. So, yeah. You guys come over to the turkey, shoot the shit. Dust is on right now. I don't think Dust has got anybody with him yet. No, it's just Dust. So you guys come over there, come on in the chat, shoot the shit. Who am I seeing so far? Big Easy's in there, Dude Knowledge is in there, Fluffy Bunny Arsenal, Tech Money, my brother's in there, 717 Riders in there, Chris Stevens is in there, Two Rich is in there. So you guys come over to the turkeys, shoot shit, have some fun, chill out. I guarantee you they are not going to put you through the fucking misery that I have. Dustin and them normally got a pretty cool chat. So come over there, shoot the shit, fucking have some fun. Burnaby, I love you, brother. And we're going to get out of here. DLD's over there now. So knowing DLD, he might come in their chat or might get in their chat. So he might come in their chat. That's kind of a weird statement. Joe Q, my brother's in there. So you guys come over to the Tactical Turkeys, get in the Tactical Turkeys chat, fucking raise some hell. These guys are cool as fuck. all about our rights, all about, the freedom and everything that we love. So you guys get over there, get in the tactical turkeys, come on in, shoot shit. Gabriel, what's up, my brother? And I'm going to end this one here. So, as always, and just for fucking YouTube sakes, I'm going to slap that in there. Kurt 24 is over there. So you guys got to get over there. Kurt's there. All the cool kids are there. So you guys be cool. Keep that thing on you at all times. And I love each and every one of you. Realize the government wants you dead, and they have no respect for your natural rights. G23, you got anything?
Hey, thanks for hosting this and doing the entire today, for the most part. Again, tomorrow they will be doing the trial again, starting at 9 a.m. Pacific, noon Eastern. So hopefully you can host it again.
Yeah.
I may try to set it up and run it on my channel also, but I'll be at work. So
well, I'm more than likely tomorrow, and this is probably my plan for tomorrow because I got a bunch of shit I got to do tomorrow. I'm going to be in and out. So as soon as they start, just put it that way, I'm going to start it on my computer at the house and probably let it play, and then I will be in and out. But if you start it on your channel, I might just piggyback off of you. So that's just the way I'm going to try to run it tomorrow. Because tomorrow, and if they go into Monday, tomorrow and Monday ought to be really damn interesting.
Oh yeah. And again, I'm gonna try to get the Monday, Tuesday, and Wednesday and today's videos. I'll probably just try to get the whole entire trial.
Dude, if you can get that, man, you gotta freaking play it, because that's gonna be watching the whole thing. It's gonna be long, but watching the whole thing, if you're like us, you'll kind of nerd out on what happens.
Yeah. And if I can get it, which I should be able to, I should be able to get it without having to file a FOIA request. But if I have to, I'll file a FOIA request to get it.
Yeah, I mean, if you gotta go through. Oh shit! Hold on, I gotta turn my way off. I'll try it without it. Let's see. I'm gonna do. Hold on one.
But if I do it,
I promise.
If I do it on my channel, it'll be kind of like what you're talking about. Is it'll just be streaming, but mine will start at 7 a.m. Pacific time because I'll have to start it before I head off to work.
Yeah.
And then I'll just have to make sure I leave the computer plugged in, so the battery doesn't die.
And I'm posting G23 stuff in the chat now. So if you're not subbed to G23, sub my man G23, and be on the lookout for any kind of streams that are coming up for all this stuff going on in Oregon. G23 covers a lot of other stuff, gun builds, you name it. G23 is right in the middle of it. So if you're not subbed to G23, there's this channel. You guys jump in it. Sub my man G23. Pretty much all of us that I see in the chat, I think we're all running in pretty much the same circles. But if you're not subbed to G2, go and sub him, man. G2's a cool dude. If you can put up with my shit, G2 is mild. He doesn't raise hell and drink quite as much as I do, but he's got a bunch of good damn content. And like I say, whether with gun builds, different wrenches that he's got to tighten up stuff on gun builds, and then he'll lead you to DJ Play Nice, bunch of other guys. It's wild how connected we are.
Yeah.
But yeah, you guys sub him. I am getting out of here. I'm gonna go grab something to eat, and I'm gonna go shoot the shit in the tactical turkeys. So, and I'll say it again. You perps be cool. Keep that thing on you at all times. G23, I love you like a brother. And let's get in. Let's raise some hell, man. Let's support some channels, and you guys support G23.
Yep.
All right, brother. We are out. Let me find the right damn tab because I'm lost. I love each and every one of you guys. Burnaby, Crow, Gabriel, freaking Warsaw, man. Love you like a brother. Fucking Chamber Defense, JLM, all you guys. We will catch you guys in another chat here, more than likely in just a couple minutes. But I'm out, man. You guys take them easy.